broadcast. Before we begin, again, can I remind members to make sure that all electronic devices are switched to silent. Order, order. We now hear oral evidence from 3 witnesses. Dr. Amanda Ward, who holds a Masters and a PhD, and is lead legal advisor to the Scottish Parliament on proposed legislation changes. Professor Gareth Owen, who is a Professor of Psychological Medicine, Ethics and Law, and an Honorary Consultant Psychiatrist at South London and Maudsley NHS Foundation, and Professor Laura Hoyano, Emeritus Professor of Law at Wadham College, University of Oxford. Before I call the first member to ask a question, I remind members that the question should be limited to matters within the scope of the bill. Can I please ask the panel to introduce themselves?
I'm Dr. Amanda Ward. You've already introduced me in part, but you contacted me.
Can you speak up a bit, please?
Yep. I am Dr. Amanda Ward. You've already introduced me. I've been involved with law reform in this space for 13 years. I'm also a member of the Law Society of Scotland's Health and Medical Law Committee. Moved to Queensland 18 months ago and took up a research fellowship at the Queensland University of Technology. But I am representing myself in an independent capacity today.
Good morning. I'm Laura Hoyano. I'm a professor of law at the University of Oxford, where I have taught medical law and ethics for many years, as well as human rights. I was a barrister in Canada for a decade, where I practiced medical law and human rights law, amongst other things. And I am currently a practicing barrister at the Bar of England and Wales.
Thank you, Chair. Hello, I'm Gareth Owen. I'm Professor of Psychological Medicine, Ethics and Law at King's College London and part of the Complex Life and Death Decisions group there. I'm a consultant psychiatrist at King's College Hospital in London, so a general medical hospital, where I'm a liaison psychiatrist working with adults over the age of 65.
We must stick to the timing of the programme motion as decided by this committee, and as such, we have a long list of people wanting to ask questions. It is one question with one answer, so if you can indicate with whom you'd like to have the exchange, that would be really grateful. Before we proceed, can I, Dr. Mary Tidball, who has a declaration of interest.
Yeah, it's just to make sure that it's on the register that I had been taught by Professor Hoyano, and indeed she was previously, well before I was elected, a work colleague.
Okay. First question, Jack Abbott.
Thank you, Chair. My first question is to you, Professor Owen, if that's okay. You've talked extensively about the complexity of the bill. I think it's fair to say from some previous speakers we've heard from this week, they also believe that the simplest safeguards are the safest as well. And by simplest, I would stress they don't necessarily mean the weakest, but they mean a straightforward plan. But do you agree with those points? I mean, one of them was made obviously by the Chief Medical Officer in terms of simplicity. So where do you kind of stand on that when you're talking more broadly about complexity as well?
Well, somewhat reminded the old adage that for every complex problem there's a simple solution, which is false. But I think we are dealing with complexity here. I think we have to accept that. But of course, complex law or law which is poor law isn't going to provide good safeguards. But the law, I think if you step back from it and think, okay, well, what is this bill really about? At its simplest, it's about the decisional right to end one's own life in terminal illness. And associated with that is the concept of mental capacity. And I've had over 20 years of research interest in mental capacity. And when I look at the issues relating to mental capacity with this bill, they're complex. But I think the other point that's important to understand is that they're very novel. So in relation to mental capacity and with this bill, I think we are in uncharted territories with respect to mental capacity, which is very much at the hub of it.
Thanks, Chair. And mine also to Professor Owen, and really to elaborate on that. Really, so obviously within the Mental Capacity Act, there's those three principles: the presumption of capacity, that a person can't be held to that capacity unless all practical steps have been taken to support them, and that a person can't be held to that capacity merely because their decision's unwise. So is it those issues that are causing you concern capacity, or is there something else?
Well, I think it's a bit more fundamental, actually, than that, because if you look at how mental capacity features in the bill, it is, and I think quite rightly, in Clause 1, the capacity to decide to end one's own life. That's the test or the concept that we're invited, and I think rightly, to consider here. So the Mental Capacity Act, which is the reference that you're making, is in Clause 3. That's where it comes in. Now, when you look at the mental capacity, and I've looked at it a lot in research, there is no experience of the decision to end one's own life. It's outside of the experience of the Mental Capacity Act, the Court of Protection, the associated research, and the experience of practitioners on the ground. So the reference to the Mental Capacity Act in Clause 3 is putting you actually into an area where there isn't experience of the central capacity question under consideration. And I think it's just very important that Parliament is clear-eyed about that. I mean, I could talk about the Mental Capacity Act in detail if you like, but that's the main point I want to make.
The Chair may cut you off, but I'm happy for you to, if the Chair allows you.
Danny Kruger.
Thanks very much. One question to Professor Hoyano. What do you think about the indemnity against civil liability that's in the Act? Do you think it's appropriate to indemnify all doctors, even if they've made a woefully bad diagnosis or botched the prescription, or in some other case actually caused some harm? Do you think it's appropriate that they should be excluded from civil liability?
I always have a problem when tort liability is ruled out by legislation. Because I think that the accountability of medical professionals lies at the heart of how our National Health Service works, and indeed all medical practitioners in private practice. So I have a difficulty with that. I think that perhaps the intention, and I'd have to ask Ms. Leadbeater if this is correct, was to ensure that members of the family who, for example, were against assisted dying in principle would not be able to bring an action that could be vexatious against a doctor who complied with the legislation and therefore should actually be not troubled with that type of litigation. So it might be that that provision could be refined.
Thank you.
Lewis Atkinson.
Thank you. It's a question for Professor Hoyano as well, please. The Act establishes offences relating to coercion, pressure, etc. And clearly in the process as set out, there was a number of checkpoints, for want of a better term, in which a person seeking assisted dying may talk to doctors, other tiers, etc. I just wondered your observations on how that criminal construct of offences linked to the different opportunities for an individual seeking assisted dying to have conversations, in your view, is likely to lead to the identification of those offences, and if you may, how that contrasts perhaps with some of those considerations at the moment where people, for example, are withdrawing decisions, withdrawing treatment in a life or death case.
Yes. Thank you. It was interesting that a number of practicing physicians who are members of Parliament in the debate pointed out that they have to evaluate freedom of decision-making and absence of coercion in many different medical contexts. And one that I would particularly point to is the withdrawal of medical treatment at the request of the patient, even if that is inevitably going to lead to death. That is considered to be a fundamental human right which lies at the heart of medical law, that a patient has personal autonomy to decide what to do with his or her body and whether or not to accept medical treatment, provided they have the capacity to do so and are acting without coercion from external sources. And doctors have to make those assessments all the time. And I would suggest that it is perhaps a convenient fallacy to say that there is a difference, that pulling the plug on a respirator or stopping artificial nutrition and hydration is a negative act, whereas giving a patient a syringe to end their own life is a positive act. Because I realize that from the Tony Bland case, I think it was convenient to say that, but there's no doubt that I think most people on the street would say that if you're pulling the plug on a respirator, that's a positive act. And yet, doctors and nurses are required to do that every day in the NHS, because that is the patient's autonomy. But if there is any question about coercion and capacity, or either of those, then the Court of Protection steps in and has the jurisdiction to make those decisions. So the Court of Protection, which I believe actually should be the court that's supervising this, not the High Court, but I believe it should be specified that it is because there are 3 levels of judges who sit in the Court of Protection, I would suggest that it should be specified as being a High Court judge, and that would mean a statutory amendment to extend the jurisdiction of the Court of Protection. But the Court of Protection makes decisions every day on whether a patient is a person with has the mental capacity to make decisions about their own medical treatment. And so this is something that they are accustomed to doing. And one aspect of that analysis is whether they are being coerced externally from doing that. But generally speaking, when a patient says, I don't want to be on a respirator any longer, I know I'm going to die, we don't ask questions, as I understand it, generally, it's not part of the protocol to say, well, are you doing this because you're worried about being a burden on the NHS? Because their personal autonomy is the overriding principle governing medical decision-making in relation to the patient. I hope that answers your question.
Thank you.
So, John Joseph.
Thank you, Chair. I think a question to you, Professor Owen. We had a written statement from the Royal College of Psychiatrists, and 65% of psychiatrists are not confident that consent can act as an adequate safeguard. And also in terms of mental capacity, they go around and saying, these decisions are opinions with a margin of error and are time specific. The person's capacity can change. What's your view on this?
Yeah, I think that is important evidence because it's coming from a body of practitioners who are very used to doing mental capacity assessments. I think of that sample, the vast majority of the sample were consultant psychiatrists. The pool, as it were, is of considerable experience. And I think it's really conveying, questionable confidence about the consent processes of which mental capacity is part in relation to the decision to end one's life. So I think it's significant evidence about the confidence that's out there in experienced practitioners. Now, it's true that psychiatrists, liaison psychiatrists particularly, I mean, I've had experience with this myself, clinically and also in relation to court of protection matters, will be involved with assessing capacity to make decisions to refuse life-sustaining treatment. Now, those decisions can be quite vexed, and they can go to the court. So the court can struggle with them. But I think an important question for the committee is the distinction, or the similarity and difference, but I think they're key differences, between the decision to refuse a treatment which is life-sustaining, which the Court of Protection does have experience of, and the decision to decide to end one's own life. They're conceptually different decisions. And, we can go into, I could outline some of the similarities and the differences now, but I think it might be helpful to actually take submissions on specifically on this question, because it's very, very important. I think there's some confusion about it. And, if you would find it helpful, the Complex Life and Death Decisions Group could write a written statement to elaborate on some of these issues. But in summary, I think that evidence from the Royal College of Psychiatrists is significant in terms of the confidence.
Sarah Green.
Thank you, Chair. If I may direct a question to Dr. Ward. I'm keen to hear about your work on the bill in the Scottish Parliament and how best practice in other jurisdictions has informed the legislation that's currently going through Holyrood? How's that influenced and informed that draft?
Sure. So I was the advisor on the previous bill in Scotland as well, under Margot MacDonald MSP and Patrick Harvey MSP, and that was in session 4 of our Parliament. We then didn't have a bill in session 5, and that is when we set up things like the cross-party working group on end-of-life choices. I did the PhD, and we very luckily saw this domino effect internationally in session 5, where there were various jurisdictions who were legislating for it. So when we came to draft this legislation in 2021 in session 6 of the Parliament, we had decades of data that we hadn't had previously when Margot made her first attempt back in 2010. So with this particular bill, the Terminally Ill Adults Scotland Bill, since 2021, we have been working with international experts. We have had various consultation processes. It's currently with the Health Committee of the Scottish Parliament. We set up a medical advisory group chaired by Dr. Sandesh Gulhani, MSP. That was a group of almost a dozen practitioners from palliative care, mental health experts, geriatricians, all other interested stakeholders, and they produced a report for us on the medicinal aspects of the bill. So that has been a 4-year process, and I understand that there have been concerns voiced in this committee that this has proceeded at pace. However, I would argue that you are not pioneers. There is 20, 30 years of data that we have drawn on in Scotland, and there's 4 years of work in Scotland that this committee and this Parliament could look to. I would make the point that the data as well is peer-reviewed and evidence-based, and that you really have to trust your international colleagues, because the data is from government bodies, it's from health departments, it's from independent academic peer reviews, it's from independent review boards as well. So we're really now looking at fact rather than falsehoods or concerns, which we were back in 2010.
Neil Shastri-Hurst.
Thank you very much, Chair. Clause 9.3b of the bill as it stands permits an assessing clinician to refer to a psychiatrist if they've got concerns about the assessment of capacity. Now, some have suggested that in fact all patients who are seeking to have a voluntary assisted death should be assessed by a psychiatrist. So my question is to Professor Owen. In terms of workforce capability and capacity, is it reasonably practicable to have a consultant psychiatrist assessing each and every one of these patients?
I think, thanks. I think the answer to that is probably not, given the current workforce. But I think another point here that's relevant to your question is that even were you to insert into the bill a very clear requirement for a consultant psychiatrist, let's say, to be involved if there was concern about mental health, what will happen in practice, I think, will be very different. So you can see this in Oregon. Oregon has inserted, or has in its law, a requirement for essentially a psychiatric referral in the case of mental health concern. These referrals basically occur in about less than 5% of cases. I think it's similar in California. So even if you put it in law, there's the question of whether it will happen in practice. And on the data, it doesn't. So I think that's a relevant consideration.
Kit Malthouse.
Well, thank you. Professor Hoyano, I'm interested to explore your views on the third layer. We've heard in previous, I understand your view about the Court of Protection, but we've heard in previous evidence, not least from eminent members of your profession, that the Spanish model of having a panel of experts might be an option that was worth examining. And in those circumstances, I wonder what your view might be about the kind of investigatory process, either that or the Court of Protection, or this type of evidence that might need to be adduced, and therefore what could possibly be in the legislation as a requirement on those people involved in the process.
Thank you, Mr. Malthouse. I have to say I do have real concerns about, as a practicing barrister, about how the provisions as currently drafted could work in terms of judicial oversight. And there are a number of unusual, if I could express it that way, functions being attributed to the court. And I first of all need to stress that the High Court and the Family Division and also the Court of Protection do regularly engage with life and death matters, but they are doing so in the context of an adversarial, not an inquisitorial system. However, we have had, since the 19th century, the invaluable institution of the official solicitor, who does have investigatory powers or functions, and who does serve in court as an amicus curiae, a friend of the court, to actually assist the court in understanding where the issues lie and in calling witnesses. I think it's not feasible at all in our current system to have the court call witnesses, nor to question them directly until they have actually been examined and cross-examined if appropriate, and then the court can put in questions as we normally do now. The court can ask for clarification. But I think that the easiest way of approaching this would be if we are going to have a judicial oversight function as opposed to a panel of experts. And to be honest, I think we've already got the panel of experts in terms of the doctors who are already involved in the different stages leading up to the final stage. I think that the investigatory function should be assigned to the Office of the Official Solicitor, preferably with an individual who has expertise in this field and who will be able to get the experience by dealing with these cases. I'll point out that Lord Justice, Sir James Munby, as he now is, himself represented the official solicitor in the seminal case on termination of life support in the Tony Bland case. And so we have a lot of experience in that area in dealing with end-of-life decision-making with the official solicitor. I think that role needs to be built into the legislation with very specific tasks set out, which include an investigatory function. The other difficulty with it currently is that it's not clear at all what the procedure would be. And with great respect to the drafters of the bill, I have never before seen such a delegation of the most essential procedural structures entirely to the rules of court in terms of practice directions or the rules of practice. We don't do it in the Family Division. We don't do it in the Court of Protection. So I think that this needs to be set out exactly what has to happen. And it strikes me that it may be that the intention is for the court to, in effect, certify that all of the procedures have been correctly followed in what has happened in the preliminary stages. And what is not entirely clear is whether the court is required itself to investigate whether the criteria are satisfied. It reads like that. I'm not sure whether it's supposed to be a review function or an actual primary decision-making function. Now, this becomes even more difficult because of the way that the Court of Appeals functions are ascribed. The Court of Appeal does not have power to summon witnesses. The Court of Appeal does not have power to question witnesses. In the criminal division, which is where I'm practicing now, primarily, the court can hear expert evidence de bene esse in order to determine whether they should send a case back for a retrial on the basis of newly discovered evidence that wasn't available originally. But that evidence will be called by the defense. And so the defense will be putting the evidence in, the Crown will cross-examine, the court will ask any additional questions they want to. But to have an original jurisdiction, an effect of what we call a trial de novo, a trial all over again in the Court of Appeal, is wholly inappropriate to an appellate jurisdiction, and I think that needs to be completely rethought. There's also a difficulty, I believe, in that it's a very lopsided right to appeal. You can only appeal the patient can appeal from a denial but not anyone else. So if anyone has concerns about the probity and thoroughness of the preliminary stages, or that the High Court judge sitting in the Court of Protection, I'll take that for the moment, has made an error of law or has failed to follow the procedures, that needs to be reviewed by the Court of Appeal. We need to have an even-handed approach here. I can understand the motivation of not wanting busybody people, to actually, as happened in one case, in Canada, where the wife had a religious objection to assisted dying, and yet there was no doubt that the husband had satisfied all the criteria. And she even went all the way to the Nova Scotia Court of Appeal because of her religious objections. And it turned out that religion turned out to be a source of great dissension in the marriage anyway. But her church was egging her on. Now, I know that you don't want that kind of situation there, but I do believe that this has to be completely even-handed legislation for it to work, and for the system to acquire public respect. Does that?
Thank you.
Simon Orfer.
Thank you very much, Chair. And, this is directed at Amanda and Laura, please. So this is about coercion, and there's a lot of natural concern about coercion in this bill, and we recognise it is a difficult thing to assess. Would either of you two change the wording or the bill to make coercion less likely?
Which section of the bill are you looking at?
Oh, now you're asking. What's that?
Have we got what we need?
Yeah, sorry, I don't know.
Just in the interest of time, I mentioned at the beginning that I moved to Queensland a year and a half ago and took up an academic fellowship at the Australian Centre for Health Law Research. That university was tasked by different government states, so by Victoria, Western Australia and Queensland, with developing the training for assisted dying implementation in those states. And I would like to just touch on the fact that the modules in that training very specifically go through coercion and how you detect coercion, how you discuss it with patients, cultural considerations around it. Of course, they cover modules on capacity and everything from the administration of drugs, but there are very, very robust modules in the training which healthcare practitioners must satisfy a pass rate of 90%, and that really supports, we rely heavily on the training to make sure that coercion protection is in place.
Yeah, so it's section 26, sorry.
One question.
If I might, I'm sorry, I was asked a question as well. Might I respond?
Yeah.
Okay,
Sure,
thank
yeah,
you.
you can.
Under the Canadian system, the provinces each have a College of Physicians and Surgeons. However, what has happened is that everyone has worked collaboratively across all 12 jurisdictions, plus the federal government. So we now have what's called the Canadian Medical Assistance in Dying Curriculum that was developed by the Canadian Association of what we call MAID, assessors and providers, in consultation with experts from across the country, which is providing a comprehensive, bilingual, nationally accredited training program that's evidence-based and based upon the learning that has happened in Canada since the legislation first was enacted. There's also a model practice standard for MAID, and there's a companion advice to profession document, which all the colleges of medical colleges have signed up to, which helps practitioners align their practice with the official guidance. And it helps assist health professional regulatory authorities to ensure that the public is protected. And coercion lies at the heart of these documents. There's also the regulations for the monitoring of medical assistance in dying require, and this is something else I would suggest be changed. In Canada, there has to be an annual report from the federal government, which is very granular in detail, from right across the country, once a year at least once a year. There was one year in which we had 2 reports, which actually go into all of these details. And so, for example, we know in 2023 that in terms of coercion, that there were, I'm just going to find this, they examined the reasons why for ineligibility, and there were 41 cases across the country in which the physicians determined that the person had not made a voluntary request without external pressure, and therefore it was declined. So what we need to know is what is happening out there, and I don't think that a report every 5 years is going to help. What we need to do is to enlist all the professions that are involved, all the professions, medical professions that are involved in actually signing up to very detailed codes of practice, but we also need the training, which Amanda has referred to as being essential. The last point I would make is that the University of McGill is launching a national palliative care hub, which is available to any practitioner in the country, in which they can receive guidance and support in helping advise patients who are receiving palliative care. And one of the options, of course, if the patient desires it, is how to deal with these requests.
Thank you. Just 26 answered the member's question. I think it's a very well drafted provision. It's very similar to what we have in Scotland. And in particular, I know we're concerned about people being coerced into assisted dying, but internationally it's actually the converse, so much so that some jurisdictions are considering putting provisions in their bill because family members are trying to put undue pressure on others to not make an assisted dying decision. On my understanding of the reporting in Kim's bill, it isn't just a 5-year review. The Registrar General is involved, the Chief Medical Officer is involved, and the Secretary of State is involved. And again, I would just commend the member in charge for the reporting procedures being very robust in this bill.
Kim Ledbetter.
Thank you, Chair. And you're right, Clause 34 does request that the Chief Medical Officer submits an annual report, just for clarity. Dr Ward, you've clearly got many years of experience on this subject. And what I'd be really interested to know from you is, what does best practice look like when it comes to assisted dying and end-of-life choice and end-of-life care? Because I think that's what we're all aiming for in our deliberations. How do we keep it patient-centred? How do we tackle also, I know you've spoken about this quite a lot, misinformation? How do we make sure that we're dealing with facts rather than speculation? And particularly in terms of how do we provide reassurance to marginalised communities, people with disabilities who understandably are nervous about this change in the law. So when it comes to safeguards and protections. So what does best practice look like?
I think to take your last point first is that we must involve them in the process and that we must have an open dialogue with them. And that isn't just in the consultation process when we are considering passing legislation. That is when you have your implementation task force, making sure that you have representation from across all the stakeholders who have been involved, including people with disabilities, including people with terminal illnesses. I would point to the fact that best practice is about balancing the autonomy, the dignity and the compassion that this bill aims to achieve by giving people the option of assisted dying, but also protecting vulnerable people who feel that there are worries and concerns. However, I would point out that having worked in this area for 13 years and seen people who would really benefit from having this option and now living in a jurisdiction that does have it, some of the most vulnerable people that I have seen are the terminally ill who want and need this choice. So I think taking a holistic approach, taking an evidence-based approach, and you will hear as a committee from the great and the good from across the board, and I'm very pleased to see that the committee is taking lived experience, because that is very, very important to inform the decision-making process. But making sure that we are going to the source of evidence, that we're using peer-reviewed data, that we're using government data. And again, as I said earlier on, you really need to trust your international colleagues who have gone before you on this, and that we need to put what the bill does versus inaccurate perceptions or speculations of what it might do. So the task here is to consider what's in front of you, not what might happen down the road.
Thank you.
Tom Gordon.
Thank you, Chair. My question is to sort of following on exactly from what we've just heard there, I think the point about a holistic and evidence-based approach is really, really critical. I just wondered, in the work that you did in the Scottish example you gave, how the terminal illness definition was arrived at, and how you capture those people who are vulnerable, who want to have an assisted death, but might then end up limited in their scope and ability to access it.
Look, assisted dying is the same as any other healthcare choice. It is always going to be limited. We are not going to reach everyone that we absolutely would want to. People who want to have this option and this choice will not qualify under a terminal illness definition, but we have to draw the line somewhere. And again, we looked at international evidence for 20, from Commonwealth countries who are very closely linked to Scotland and the UK, and we drew the line with the definition that the person has an advanced progressive illness from which they are unable to recover and that will cause their premature death. And for us, that demands the support of members of Parliament in Scotland, and that demands the support of the public. And again, I would really stress the fact that each jurisdiction has to legislate according to its own constitutional, societal, legal and cultural considerations, and that's what we have done in Scotland, and that's the definition that's working for us now. Previously, there were attempts that were more liberal, that didn't gain the support of the House, and we believe that we have arrived at a situation that is very similar to the definition of terminal illness here in Westminster, that is both safe, compassionate, but also draws the line so that people who shouldn't be able to access this don't.
Thank you.
Naz Shah.
Thank you, Chair. Professor Owen, we had Professor Alan House giving us evidence yesterday on talking about capacity and coercion. I just want to pick up on some of the concerns. So in all 4 of the jurisdictions that collect data on the issue, Oregon, Canada, Western Australia and Washington, between 35 to 59% people cite being a burden as a reason for assisted dying. So what I want to ask is, what do you think is the level of confidence of psychiatrists that to assess capacity and consent reliably, and what would your concerns be, if any?
Yeah, I mean, this is a an essential question. I mean, okay, so I work clinically in over 65 age group, quite a lot of terminal illness, some of it in the last 6 months. So it's a population, so you have to understand the population. The population is, as said, it's typically over 65, it's frail, there can be a terminal illness very typically with comorbidity. That comorbidity is often mental health comorbidity. So depression, 20% rates thereabouts. Delirium, cognitive impairment is very common, often not picked up. Patchy safeguarding, patchy access to social care, and as you I know been hearing, patchy access to palliative care. So that's the ordinary person in the NHS. Now, I know people who select into assisted dying are not necessarily that sort of mean person, so to speak, but that's just a picture of what it looks like for me when I go to work, basically. So that's where one's starting. So now think about burden. Okay, well, this is a group that do feel very burdened. Some of that you might think is excessive. Some of it maybe is natural, given the life stage. So it's a mixed picture. But when it comes to pressure coercion, I know you've been grappling with this a lot as a committee, and I know there have been some amendments that address this. And we've talked about Clause 26, particularly in relation to this. And, of course, you can, when it comes back to the training question, you can take evidence on the state of safeguarding, how people are really able to assess coercive control, domestic violence, and so on. I'd like to draw attention to something else which I'm not sure has come so much to the attention of the committee, which is not the offences. It's not the criminal side of this. It's the common or garden capacity assessment side of it. So this relates really to Clause 1, actually, and which is the issue of how you deal with interpersonal pressures in somebody in a situation where there may be a mental health problem. There may not even be a diagnosis. You may be talking about a kind of cognitive impairment that's not reached the threshold or a diagnosis of dementia. You may be talking about a kind of mood problem or an anxiety problem that's subclinical. One may be talking about a level of intelligence that's not clinically a learning disability, but it's there. And it's interacting with a form of pressure within a family, let's say, which is often not malign in its intentions, but it exists. It's a very overvalued relationship, for example, a strong sense of loyalty to somebody, or an enmeshment, for example. And that what you have are situations where there's an impairment and also an interpersonal pressure. They're interacting and they're amplifying each other. Now that can have an important consequence in terms of the functional ability of mental capacity. And outside of the assisted dying context, when you look at that in the Court of Protection, and the Court of Protection have been struggling with quite a lot of cases like this, that's recognised. That phenomenon of interaction that I'm talking about there between interpersonal pressure and impairment is recognised. It struggles with it. I've been involved in some research to try to structure the understanding of it. But this is not at the point where it's a kind of training manual which you can lift down from the shelf and roll out across the workforce. It's much more in a kind of R&D, research and development phase. So I think it's just important to draw attention to pressure, not necessarily as malign in its intention, which is nevertheless operating in these situations, which can have subtle impact on the functional tested decision-making capacity. And just to bring us back to what is it? What is the decision-making capacity we're talking about? It's the decision to end one's own life.
Lambos, Charles Lambos.
Thank you, Chair. This is a question for Dr. Ward and Professor Hoyano. Yesterday we heard evidence about the interplay between assisted dying and the Equality Act and the European Convention on Human Rights. So my question is, how could the acts be, are there any amendments that should be made into the Act to deal with those issues? And what are your thoughts about the interaction between those bits of legislation in the bill?
Any amendments that should be made to you said the Act,
So
to
the
mean
bill,
the bill?
sorry, I meant the bill, yeah.
So I heard the session yesterday and would agree with the comments that were made there, particularly around proportionality. Article 2 is an absolute right, that's the right to life, whereas Article 8 is a qualified right, and it's about, again, that balancing act. The courts have been very clear that we need to protect vulnerable people, and I feel very strongly that the bill shadows that very well by giving choice, but in a very limited set of circumstances. My understanding of the Equality Act as well, I know that there's been some claims made that this happened in Scotland, was that the definition in the Equality Act of disability would cover people who are terminally ill. That is not my reading of it, and that is widely shared by the people who are advising us in Scotland in the legal capacity as well. That's probably all I've got. Do you want to add anything?
I would only point out to the committee that the common law has entrenched the human rights of the patient a long time before the Human Rights Act 1998. So we must remember that this is we don't just have to look at the European Convention and Strasbourg. The common law has been very active in entrenching fundamental principles of the rights of the patient, and in particular the autonomy in decision-making regarding its own body, long before the HRA.
Time is allowing us to have 8 more questions. 3 people have indicated. I'm going to start with Danny Kruger. Does anybody else want to, and Simon Over? Thank you. Danny Kruger.
It's great hearing a case for the common law over the Human Rights Act. Yesterday we heard about parliamentary sovereignty. This is a tremendous process we're having here. Putting that aside. Professor Owen, Professor Hoyano said that a person in the street wouldn't see the difference between a patient requesting to die by the withdrawal of treatment versus the active administration of fatal drugs. Whereas I think you said that you did see that there to be a profound difference between that decision on behalf of the patient, but also presumably the act on behalf of the medical professional in the case either of withdrawal of treatment or of the administration of fatal medication. And you said you'd be happy to draw that out. Could you do so?
Yeah, I'm happy to try now, but also to do it further with some written submission. It would be helpful because it is such an important. Firstly, the man on the street, or the person on the bus, so to speak. So the one thing I think to remember, and this comes out actually in the public opinion polling, that when you're asking about assisted dying, some people think that that's access to palliative care. So, there is a degree of misconceptions that are out there in the public which are important to bear in mind here. But the distinction, the distinction between the decision around refusal of life-sustaining treatment and the decision to regarding assisted dying. What are the similarities? Well, they're both about life and death. What are the differences? Well, one's a refusal, one's a request. One is traditionally considered to be about bodily integrity. It's the so-called shield of the person or the patient against the intervention on the body of that is being made by the medical professions. You're giving the patient there an important right, which is a shield-like right. And that contrasts with a request for assisted dying, which is a request. You're involving other people in an act which is an act of ending one's life. That's not something which, at least, going back thousands of years, is something the medical profession has been comfortable with. So, you can discern a number of different differences. Could you reduce those differences to one thing and one thing only and be particularly precise about it? Probably not. I think you're talking about differences which cluster and group and we overall accept as a difference of kind. I think the other issue here that's important is intention. So when you're assessing somebody's decision to refuse a life-sustaining treatment, the doctor there is not having the intention to end a person's life. I think that would be a concerning intention were it were there, and sometimes it's looked for actually in the if it's disputed. But of course, when a doctor's involved with the process where somebody is seeking assistance in the ending of their life, it's quite difficult to say that the doctor doesn't have an intention to end life. So again, that's I think one could go on, actually, with the discussion of the differences. But the similarity is that we're talking about life and death. Yeah.
Kim Ledbetter.
Thank you, Chair. This is an incredibly helpful panel, so thank you for all your expertise. If I can just come back to the content of the bill and to some of your points, Professor Owen, in terms of capacity and coercion, I think we're absolutely having these really important conversations. But what concerns me a little bit is if we're saying that two doctors, potentially a psychiatrist and an oncologist and a judge, are we saying that between them we're not confident that assessments of capacity and coercion can be made? And what does that mean in terms of things that are happening at the moment, as we talked about withdrawal of end-of-life treatment and those things, that those assessments must be being done now all the time, but at the moment there's no legal framework around that. So surely putting a legal framework around that and having all those multidisciplinary people involved has got to be a positive thing. Professor Hoyano, I'd appreciate your thoughts on that.
Yes. Well, as I say, I think that whereas I completely respect Professor Owen's expertise in this, as a psychiatrist, as a lawyer, the question of capacity is a yes or no, necessarily. But capacity is always determined by the Court of Protection in respect of the decision that must be made by the person concerned. Do they have the capacity to do it? And so I think that when we're talking about a determination of capacity here, and also coercion, which of course is part of capacity in a sense, because capacity is the autonomy of decision making. then you're going to be actually having this very focused inquiry. Not whether they have capacity to manage their financial affairs. I probably don't have that capacity. But on something like this, I would. So I think that that's important to recognize that it is a yes or no question which the law has to draw and does draw, depending upon the expertise of psychiatrists like Professor Owen, but also forming its own judgment from its own experience, which is why I think the Court of Protection really is the place that this should be. There is one aspect of the bill which worries me a lot, and that is the number of people that will be excluded by the provision that the medication must be self-administered. This would mean that Tony Nicholson, who went all the way to the House of Lords to try to get the right to die, could not have it under this bill because he was paralyzed. He was a tetraplegic, basically. He was paralyzed from the neck down, limited movement of his head, and he from a stroke. And he lived for 7 years with that condition, and he would not have been able to self-administer. And in fact, when he was denied from the House of Lords, anyone who's seen the Channel 4 program and watched him wail in despair and then refuse all nutrition and food, hydration from that point onward until he died. That was the death he didn't want. And I think we need to recognize that there are problems like that. Now, in Canada, across the entire country, in 2023, only 5 patients opted to self-administer the medication. Only 5. And even when they were capable of doing it, they wanted the doctor to do it themselves instead. So let's remember that as well, please.
If I can just make a really quick point on the self-administration, because this is something that we looked into in great detail in Scotland. We chose self-administration in Scotland specifically because it doesn't just include ingestion, it doesn't just include swallowing. There are a range of ways that you can self-administer the medication, and I'm happy to provide that to the committee if that would be helpful.
Lewis Atkinson.
Thank you. Professor Owen, can I just probe a little more on something you raised before, that interaction, I guess, of potential impairment, potential family dynamics, etc., in a way that is not malign, but I think you think is a consideration. I think we've heard some evidence over the course of this week around whether there would be any benefit of a more multidisciplinary approach that can take a more rounded psychosocial assessment of someone's situation in line of this, which would be less about the clear test of is there capacity or not under the Mental Capacity Act, but more about those wider considerations of those interactions. I just wonder whether the inclusion of, say, social workers, mental health professionals as part of a multidisciplinary approach on that would give you any reassurance to those points that you made.
Yeah, good question. Just on the point about that interaction thing, it's not just me picking it up; it's the courts and the Court of Protection particularly. And if you're interested, that's reference 11 in the written submission from the Complex Life and Death Decisions Group. But yes, I think the point that you make is well taken from my point of view. So you have 2 doctors essentially doing the assessments. Now, doctors, some of them can be very good at assessing social circumstances. Some not so good, really. So I think it would be preferable to try to get a law here which gets sight of social circumstances. And one way of doing that possibly may be to insert in a requirement that a suitably experienced social worker is involved. So that there's some sensitivity to these contextual, relational, interpersonal effects, which can be, as I know you're aware, can be very subtle. I mean, a lot of these things are extremely difficult to pick up. They're easy to miss, and then even when you're aware of them, there can be dilemmas about what to do with them.
Chair, might I just add a postscript to that? Which is a model which we could consider in this context as Kafkas in the family courts, which is a body of experts who are civil servants in effect, but they are independent, but they are accustomed to dealing with specific contexts. with social workers, for example. Now, they represent they investigate what should happen to a child in a public law or private law proceedings. But we could, it occurs to me that something like that, with a report from the equivalent body to the solicitor's office that I've been just mentioning before, could be a very good way of building that in, because I completely agree that social workers are likely to be more professionally attuned by virtue of their training and experience to looking at the wider context.
Getting on in 2 minutes for question and answer. Simon Orfer.
Very quickly, actually, the honourable member there asked my question, but there's another question I want to ask very quickly. Do you think, we heard yesterday about domestic violence and elder abuse. Do you think there's any tightening we need to do in the legislation around that type of area? So coercion into older people to take their own lives early for potentially financial benefit?
Picks up on the previous question that my learned colleagues have answered as well. What legislation does, and what good legislation does, is it sets a baseline and it sets a legal framework. You can take a kitchen sink approach to legislation and you'll end up with something that in practice is completely unworkable. There's an awful lot that guidance needs to pick up and should pick up. I understand that only certain things are appropriate for secondary legislation, but when you try and legislate for every eventuality in the actual bill, whether that is with, on my reading of the bill, there is nothing that prevents a multidisciplinary team from being involved with this. What the bill does is it sets the baseline of a minimum. There must be at least a minimum 2 doctors. Then in practice, and picked up in guidance and in secondary legislation, which should be developed in conjunction with professional bodies, clinicians, allied health, social work. They are the appropriate people to develop that guidance, not legislators. So that's what I would say is just draw caution with how much you're putting on the face of the bill, because you might end up with something that is unworkable.
Last question, Asha.
Quick one, Professor Owen, again, just following up on that. You talked about that interaction that Mr. Atkinson just talked about. What are the gaps in research? Where are the actual gaps right now?
Well, yeah, I think there are lots of gaps, and I think take this point with my intention correctly. That I don't say that as a downer on this project. I say it because it's true. There are just lots of gaps, and so we're going into this it's uncharted territory, and so you might think it would be good to have more of a map before starting. And this is one area where I think there are evidentiary gaps. So it's just not clear how those sorts of interactions should be assessed. What sorts of thresholds should be set, what kind of training and so on should be available. Now, I know that there's been a lot of talk about training, and training is all very well and good, but you need to know. You need to know what the point of the training is, what the purpose of the training is. The training it's got to be valid before you can roll it out. It's got to, and there are just lots of gaps here, basically. And relating to this about the question of mental capacity assessment, it's often said, well, why are we worried about mental capacity? We've got so much experience of doing it in health and social care contexts now. We've got the Mental Capacity Act, we've got the Court of Protection, we've got all this experience. We do, and that's been extremely important work that's been done since the parliamentary discussions you had about the Mental Capacity Act all those years ago. But in relation to some areas, it's being done reasonably well. So in relation to treatment, care residence decisions, one can talk about a body of professionals that understand the concepts, can do the assessments, and can achieve, at least when trained, good levels of agreement, so you can get the system to work. But in areas of decision making where the decision itself is unsettled or conceptually much more profound or novel, and I would suggest that the decision to end one's own life has those characteristics, you can't expect there to be such levels of reliability. You just can't expect that. And there are examples in other areas where the decision making is unsettled, where you can show this empirically, actually. So the question of how well capacity assessment works is actually matter specific. And that isn't to be that shouldn't surprise us, because the whole concept of mental capacity is that it's matter specific. That's the whole functional idea of mental capacity. And the matter here is the matter of the decision making to end one's own life.
Thank you. Thank you. Order. That brings us to the end of the allocated time for the committee to ask questions. I thank the witnesses on behalf of the committee for their evidence. Thank you. We can swiftly move on to the next panel. Members wishing to ask a question of the next panel, could you please indicate as quickly as possible? Kit Maltos, Mary, Tom, Rachel, Naz, Kim, Danny, Tom, Neil, Jack, Sean. Did we get them all?
Lewis as well.
And Lewis as well?
Yeah.
We now hear oral evidence from Professor Nancy Preston, Professor of Supportive and Palliative Care at Lancaster University, Dr. Naomi Richards, Director of the End of Life Studies Group at the University of Glasgow, and Claire Williams, who I believe is joining us, or somebody's joining us by Zoom, who is head of the Pharmacovigilance and Regulatory Services for North West East Health on Zoom. And we have until 3 p.m. Could the witnesses please introduce themselves for the records?
Preston, I'm a Professor of Supportive and Palliative Care, Co-Director of the International Observatory on End of Life Care at Lancaster University, and I'm the co-lead for the European Association of Palliative Care Task Force, where we're trying to prepare guidelines for clinicians in countries where there is permissive legislation on assisted dying to help people whether they're involved or not involved.
Hello, I'm Dr. Naomi Richards. I'm Senior Lecturer at the University of Glasgow and Director of the End of Life Studies group there, which is a teaching group.
Hello, I'm Claire Williams and I'm Chair of the Greater Manchester Research Ethics Committee. My background is one of nursing, but my focus for many years has been on ethical decision making in clinical research, and it's this work that's inspired the proposal that I submitted. As you're aware, the proposal outlines a committee-based model for decision making in assisted dying cases, offering that alternative framework that places sole responsibility on a High Court judge. I believe this approach is far too narrow for such complex and sensitive matter, and simply too much to expect one person to carry that burden alone. So the proposal really shifts that responsibility from that one individual judge to a panel of professionals, ensuring that decisions are made collectively with robust safeguards in place.
Thank you. Again, can I ask colleagues one question indicating who you wish to answer, and if there's time at the end, of course, I will open the floor for further questions. I'm going to open with Sean Woodcock.
For Claire Williams, really, about the drugs that are used in the various jurisdictions and how that interplays with your view on should this law come into place. What are your views on the drugs that would be put forward for the assisted dying?
I'm not familiar per se with the types of drugs that will be used for assisted dying cases, but in terms of my experience in research ethics, we do make life and death decisions. On a daily basis, decide whether we would offer patients the opportunity to take very experimental drugs, and that's particularly difficult when dealing with terminally ill patients. So what's so beneficial with using a committee-based model is that those decisions can be made collectively, and decisions are very similar and have real parallels in terms of we need to ensure patients are fully consented, that patients have capacity, and that there's no coercion involved in terms of recruiting patients to clinical trials. So that's how I really see those parallels and how I feel assisted dying cases should be considered.
Jack Abbott.
Thank you, Chair. My question is for you, Professor Preston, and obviously you have real extensive research into palliative and end-of-life care. So I think it'd be really helpful for the committee if you could maybe describe some of the underlying motivations about why people come to the decisions they do about when choosing end-of-life care, and how you feel assisted dying would sit as an available option to those making those decisions, if it was available.
So I think the decision to go into palliative care, I think that's what you asked originally, is that right? Yeah. So the decision is often made more by a clinical team to recommend that there's probably changes in the goals of care and what we're trying to aim to do. We've got 2 big European studies looking at that at the moment in COPD and in cancer. And it's trying to get triggers so that those things can happen, because people can't make decisions unless they're informed and they're aware. And I think equally then when it comes to assisted dying, people often make these decisions. We've done interviews with bereaved families and healthcare workers in the United States, in the Netherlands, in Switzerland, and also British families who access through Dignitas. And it often comes, there's something they've really thought about for a long time. This is what we hear from the family members. And it might come to a crunch point where they know they're potentially going to lose capacity. They're potentially going to use the abilities that for them are important. For someone else, this may not be an issue at all. And that's when they start to seek help. And they usually seek help first from 1 or 2 family members. There's often a secrecy around this because you don't want everyone talking about this. It's quite exhausting to talk about. It's a decision you've made. And then they seek help from the healthcare professionals. And that's where they get a varied response. So depending on who you access, because it's a bit of a lottery, because it's only going to be a minority of doctors willing to do this, that's where the challenge comes in.
Neil Shastri-Hurst.
Thank you, Chair. And again, my question is directed to Professor Preston. In your written submission, you propose effectively reversing the presumption of capacity that's set out in the Mental Capacity Act. Just wondered if you could go into a little more detail about that and the reasons behind that proposal.
So the submission was with my colleague, Professor Suzanne Ost, who's a Professor of Law, and this very much came from Suzanne. And I think it's just to give it that bit of extra concern that maybe if we don't presume capacity, but actually we have to almost presume, is there not capacity? A bit like if you go to A&E with a child and they have a fracture, the presumption there is, how did this happen? And do we need to rule anything out? Rather than just assuming, well, they've just fallen over, is exactly as has been said. So there's an element of that where maybe if we're not presuming capacity, but we're actually going into it to really, really sort of switch it round within the training to say, do they have capacity? But that would be a change within the Mental Capacity Act, I think.
Thanks. It's a question for Dr. Richards, if I may. In light of your research, could you just say a little bit more about the weight that dying individuals, place on the importance of autonomy and how that is weighed up against, other considerations around safeguarding, etc.?
Well, there's 2 things I'd like to say about this, really. The first is that it's individually specific, which probably wouldn't come as a shock to you. And so it really is about the evidence shows that the people who request assisted dying are people who have perhaps a particular preference for control in their life, and they have had this preference across their life. So it's part of their identity. And in that sense, it's a personal preference as opposed to a deficit in palliative care, which is what we hear a lot about. And the second thing I'd like to say is, with regards to autonomy, is that the proponents of assisted dying are very keen to emphasise that this is an autonomous decision, which it is, and it would have to be by virtue of the law. However, that doesn't mean that families and loved ones and close social relations are not really embedded in that decision making. So it's important to think of relational autonomy rather than just a sense of autonomy as just an isolated individual making a decision not in relation to others. And so it's really important to also think about the impacts on family when you're thinking about the guidelines that would go along with any legislation.
Thank you very much. A question for Claire Williams, please. It's interesting that you said that you weren't aware of what drugs might be used in assisted dying, and obviously we don't know yet what will be proposed here if we pass this law. And there are lots of different combinations of drugs used in other jurisdictions, and we don't know very much about them. I think that's fair to say. What we do know is that a lot of the combinations, 2/3 of deaths, I think, in Belgium and elsewhere, and in the United States where I've visited, the first drug that's used is an anaesthetic and then a paralysing agent. So there's a paralytic drug is introduced, which often gives the impression that the patient is having a peaceful death, but we don't actually know what is going on beneath the surface, except, I'm afraid to say, from studies into people who've been on death row, who've been legally executed, and there is evidence of brain trauma. Can you speak to this at all? And do you know, we do know that there's certainly, in a minority of cases, real complications that occur. Often takes a very long time for the patient to die. How do you think and there's vomiting and all sorts of distress in a minority of cases, how can we improve what we know about the actual process of dying, and how can we reduce these terrible complications?
I can only apologise because I'm here in terms of giving evidence around more of a model for collective decision making rather than actually having experience with regards to these drugs and as you say, the potential side effects and prolonged death, which obviously is something that we will really need to consider for these cases. Obviously, we need to take evidence from other countries that have had this experience. So apologies that I can't comment on this particular aspect.
Thank you.
Kit Malthouse.
Thank you. My question is to Dr. Richards. Obviously, the health service medics and the others are dealing with end-of-life situations at the moment, withdrawal of treatment, or indeed, I think doctors can decline to give treatment if they think it's futile. In those circumstances, there are a set of safeguards. How do those safeguards compare with the safeguards in the bill? And do you think there's any adjustment required from your research to the safeguards that we've got in the bill at the moment?
So I think what I would say to that is that assisted dying is something that's quite categorically different to those end-of-life scenarios that you're talking about there. And so you would expect just a very different set of safeguards, I think. I think it's a sort of misunderstanding to think that assisted dying is of a piece with other life-ending decisions, when actually it's really something quite different, and so requires a different framework. That's what I would say to that.
Harry Tidwell.
Thank you. And my question is also for Dr. Naomi Richards, though if Claire Williams has anything to add on that, it would be really helpful. So we've heard evidence from overseas about the value of doctors being able to have holistic discussions about end-of-life choices under an assisted dying law. What research is there on patient experiences in those jurisdictions, but particularly the evidence around quantifying the experience of dignity and respect in end-of-life choice-making where assisted dying is available?
Quantifying dignity and respect.
Or real-life examples. Through you, Chair. Apologies.
So the question is, what is the evidence about trying to find out about this interactional space where you're asking about the people's motivations? Is that...
Chair, is that okay if I clarify? Thank you. So there's two elements to my question. One is talking through the available evidence on how these holistic processes work in countries which have assisted dying. It's the first element. The second element is really reflecting on, we've heard a lot about choice from witnesses across the last 2 days, but a lot of the consideration about choice is to enable patients to arrive at greater dignity and respect in their deaths. And it would be useful if you can reflect on any evidence around that element too.
I'll have a go and then maybe. So holistic processes, I assume that you're meaning in terms of the kind of multidisciplinary team conversations which we talked about in the previous session. There isn't, maybe Nancy does know the evidence about this. What I would say is that talking about gaps in research is that, I mean, I'm an anthropologist, so I'm interested in the kind of discourses and the conversations that are happening there, and I think there's a lack of evidence about that. So we have a lot of evidence where it's kind of tick boxes, for example, about motivations, about procedure being followed, these kinds of things, and we have less qualitative, in-depth, interactional evidence about this kind of holistic decision-making, I would say.
So we've done some research where we've interviewed doctors, healthcare workers who have had these conversations, whether they're majority against, but they're still having these conversations, and also the experience from the bereaved family of what that was like to have those conversations. On the whole, there are still predominantly the conversations about palliative care. Can we do something different? How can we meet your needs? How do we assess your needs? And in some cases, the doctors in palliative care, particularly in Switzerland, would never really suggest, certainly would never suggest assisted dying, but if the patient asks for it, they equally don't advise them how to get an assisted death. And in some cases, they said they sort of consciously blocked the conversation so that the person timed out and couldn't have it. So I think the emphasis is the other way. Perhaps in places like the Netherlands, Belgium, where it's been around longer, it's much more integrated into other services like care homes, palliative care. It's part of a holistic assessment. I remember visiting a team in the Netherlands, and when they got a new patient, said, so we assessed them for, where their preferences, whether they want to die, about resuscitation, about advanced care planning, about euthanasia. And my jaw dropped. I was British. This was illegal. And they do it in such a natural way. And they said, well, we need to plan for that for them because we need to understand what is right for them. They're not suggesting it. They're just trying to take it on board. So I'd say the predominance of the conversation is about palliative care, but if the patient wants the assisted death, then either they might assist, which is rare, or they might suggest how you go to a right to die association, but more likely they will still tell you how palliative care can help you. Thank you.
Naz Shah.
Thank you very much, Chair. Professor Preston, in your written evidence to this committee, you said Parliament should, I quote, consider whether there should be a stated exception to the usual presumption of capacity under the Mental Capacity Act 2005 in the bill. What kind of standard do you think Parliament should consider adopting instead of the use of a Mental Capacity Act, and why do you think this?
So again, this came from my colleague Suzanne Ost, who's the Professor of Law. But it was just to say, I think as Naomi said, this is something very different. This is something, it's very different to choosing to consent to an operation or even a research study. This is finite. It's a finite decision. So therefore, the assessment should be a bit more. What I will say about mental capacity is we had a PhD student who assessed mental capacity by hospice care staff, particularly doctors, but also a lot of the nursing team who were making the decisions. And she was a lawyer, and her conclusion was it was incredibly well assessed. This was in terms of safeguarding, so when people were going back to what we might consider unsafe homes, but that's what the person wanted because their life was that unsafe home. Their life was that, I'm talking about maybe social deprivation, things like that. That was their life, that was their home. And whilst the people who, in this particular team, they were very good at assessing that and applying the Mental Capacity Act according to her research.
Thank you.
Richard Hopkins.
Thank you, Chair. And if I can direct this to Claire, and you mentioned, multidisciplinary teams and decision making, and we've heard over a couple of other evidence sessions from palliative care social workers, nurse practitioners, the Royal College of Nursing, about that multidisciplinary approach in care. And I was wondering what your thoughts are around the ultimate approval as set out in the bill being, doctor, another doctor, and then a legal okay at the end, and whether actually a more multidisciplinary approval approach would have more stronger outcomes, better safeguards. I'd just welcome your views on that.
Yeah, I absolutely agree that a panel committee approach would have better safeguarding for patients, because the decision is being made collectively with that legal expertise, with, as you say, other healthcare professionals that might be palliative, or with ethicists like myself. It's having that collective view, ensuring everybody's happy that that's exactly what the patient wants. So I do believe that it should be a committee panel based approach for that final decision. And I think, as I said before, expecting a High Court judge, just one individual, to make that decision alone, I think it's hugely burdensome and not an approach that we should be taking.
Thank you.
Tom Gordon.
Thank you, Chair. My question is to Professor Preston. We've heard from a wide range of different people from different jurisdictions, and what we've heard and the evidence suggests that where we see assisted dying, as an option, we tend to see improvements in palliative care. I just wondered if you had any comment on that and how we could better integrate into giving people that choice. I know when you were talking earlier, you talked about different routes and different systems in countries where they might have it sitting outside. Would that not limit that choice? Would that hinder people's abilities, or how do you sort of see that having sort of a play in this?
I think there's getting a bigger conversation in a lot of these countries, including the Netherlands and Switzerland, that this is not about healthcare. I know that sounds a really strange thing, but it's about self-determination and it's about a life choice. And I remember someone saying to me, well, you wouldn't check who I'm marrying. And they feel it's like such a personal choice. So I think patients do bring this up. They bring this up all the time now. Studies have shown in Spain that if a patient has a desire for hastened death, the best thing you should do is explore that desire. Why do they have that desire? How can we help you? Are there other needs we can meet? And for most people, they will not want to then go ahead and have an assisted death. I think these are a minority of people. Can you just remind me the rest of your question?
It was just about in terms of if you have systems where assisted death is offered outside of the healthcare setting in some of those countries around the world that you mentioned, how does that then limit people's access to it? Is that something that you think has an impact?
I think it almost enhances their access to it, because at the moment they get lost in the system because they're usually trying to find these two magical doctors, because in a lot of countries you've still got to find these two doctors. Most doctors, even if they approve the idea of assisted dying, do not want to partake. They might assess, but they might not prescribe. They might prescribe, but they wouldn't administer. So trying to find these doctors to do it is really quite challenging, and that's what we get back from the bereaved family interviews. How do you navigate a system where you cannot access the people you need to get to? And people go doctor shopping. They're going to multiple doctors until they might get the right answer as well. So if you keep it safer outside of healthcare, so they can talk to their doctor, they will mainly talk to their nurses, because they're the ones who do end-of-life care predominantly. And they can say, well, actually, that's not something we can do. But if you want to see, we've got a stand there with information about it. This is the service you can go through. And same with the GP, things like that. I think it might actually make it more easy for people to navigate, and that's where I came to the idea of keeping it outside, was actually as a supportive way for patients and families, because on top of all this they're dying, they're having a really difficult time, and we're trying to get them to navigate services that are incredibly difficult when you're trying to find two doctors. And on top of that, just finally, it's quite secret who does this. Doctors don't want to tell people. I've had people who do this who might just assess, they may not prescribe or administer. They don't want people to know in palliative care because it doesn't go well for them. They're concerned that people will not like it. So I do research in this area. Some people think that means that I'm trying to push for assisted dying. I'm not. I have a neutral stance. I'll say things pro, I'll say things against, but it's quite difficult for people involved. So there's a bit of a taboo, there's a secrecy, so it makes it even harder in the bill to say, recommend another doctor. That will be a challenge to find that person.
Can I
Simon? Oh, sorry.
Sorry, could I just add something to
Quickly,
that? And I mean, the evidence does suggest that one of the implementation challenges with assisted dying is finding doctors willing to participate, consciously participate in this practice. However, I think what you're asking there is about a sort of more Swiss model of assisted dying. And there is a reason that the Swiss model of assisted dying has stayed in Switzerland and gone nowhere else. It has not transferred or translated to other jurisdictions because of its uniqueness and because of the practical challenges of disentangling it from a healthcare system. So I think that, it's really important to recognise that I think you were also really talking a little bit there about disentangling it perhaps from palliative care. And it's really important to recognise that the vast majority, the majority of people who request assisted dying, receive assisted dying, are actually within palliative care. They are already, as I'm sure you've heard already. So to kind of disentangle assisted dying from the specialists in communication around end of life would seem to be a kind of self-inflicted problem of design, in my view, because it's safest being held there by the experts for those who want to get involved in it, and it's safest being held in the healthcare system. As I say, there is a reason why the Swiss model, where it is the only model where it happens outside of a healthcare system, is localised to Switzerland.
Dr. Simon Ofer.
I'd like to ask Claire this, and this is about medication, but not specific, the drugs and everything. At the part of Section 18, provision of assistance. In Australia, we've heard that the medication is left with the patient, whereas under this legislation, the doctor or the coordinating doctor brings the medication to the house or the place where the patient wants to end their life. Do you feel, having seen the Act, that that's safe, or do we need to amend it in any way?
I think, again, there would need to be those safeguards in place. There would be concerns if they weren't actually giving the drug to the patient and seeing the patient take the medication. So, yeah, I think there would need to be robust safeguards in place.
Well, can I ask a further question, Chair?
Can you wait for supplementaries? I just want to get Kim Ledbetter in and then we can come back.
Yes, certainly, yeah.
Kim Ledbetter.
Thank you very much, Chair. I think we've heard a lot from witnesses this week around safeguarding, and this is something I'm really keen to pursue in terms of there are a significant number of safeguards already in the bill, but is there anything else that you think we could add? And I think the Bill Committee are all interested in hearing these ideas, particularly thinking about how we can protect people when it comes to people from disadvantaged backgrounds, older people, and I think Dr. Richards, you've got experience working with older people, people from a range of different backgrounds, people with disabilities, so that we are actually keeping the bill very much focused on the people it's designed to help, terminally ill people with less than 6 months to live, but addressing more of those broader concerns around some of the inequalities in society. Do you want to go first?
Yeah. So we did research in COVID in care homes, and of course there was that real concern about do not resuscitate orders, emergency care plans that were blanketed across the care homes. The care home staff were traumatised by this, so there is real issues. I think we know there's real issues day to day in how people are treated within the NHS. I think it's unconscious. I don't think it's, people are intending to do it, but we know people are treated differently and different things are done. And that's partly why we think a system outside of it would protect them, because then you're not within the team, the healthcare team who are treating you and giving you advice about those things. Whereas if you are having to opt into a system, you're having to do something more, they won't feel like it doesn't happen in the hospital, and this trust. So one of the issues in Switzerland, and just to say that it is being adopted in Germany, the same Swiss system, and Austria already have a panel. So what they're trying to do is protect these people by keeping it one step removed, so that people don't feel that they're trying to be, had an assisted death. So the hospitals in Switzerland, most will not allow assisted dying to occur in it, because they do not want a lack of trust with their patient group. Instead, they will sometimes allow the Right to Die associations in to do this, and there are just a few hospitals that do allow their staff to do it. It's all about trust.
Okay, that's really helpful. Dr. Richards?
I don't think there is any evidence that there is a loss of trust in doctors post legalisation. I wanted to add that, but I think it is so important. This is not, as I said to the earlier question, this is a categorically new thing that would be coming into society, that is going to cause cultural change in how we approach, think about, anticipate dying. It's a big deal. I know you all know that, but so accompanying that needs to be, a really sensitive, informational kind of deliverance that is appropriate across society, that is going to alert people to this, particularly if you're going to have a system where doctors are not allowed to raise it with patients, then people need to know about it. So that's one thing. But also in terms of reducing any of people's fears around it, so that there is so many misconceptions about assisted dying, even amongst people who have spent quite a lot of time reading and researching it. I think it's a very simple thing, but the discourse in society has been going on for so long that it's really that there is a lot of misunderstanding.
Can you give me an example of that? Sorry, Chair. What do you mean by that? Can you give an example?
Misunderstandings of what it is. Well, fundamentally, that it's not based on the principle of autonomy. That it's something that can be done to you without your consent. You wouldn't want the general public thinking that. A very basic level, understanding that assisted dying, the very phenomenon that term encapsulates, is a phenomenon that starts with the patient. It's a request made by the patient because of their subjective assessment of their quality of life as they're dying. So at a very fundamental level, you'd want to communicate that to the public. So it's a huge piece of work to have to create an informational context that's variegated according to the position, the starting position for people's knowledge base around it, and to bring something in that doesn't scare the public, and they see it as something that can be positive. And you do see. I think in jurisdictions that have legalised, even post-legalisation, there continue to be elements that are resisting it. But you do start to see positive stories of, the kind of, the sort of the ceremonial aspects that can come when you can time death. There's a whole cultural piece around, new rights around dying that are being created. When people choose to have an assisted death, and the sort of the new dying time or space that is opened up there, and the intentional actions that can happen from people's social groups. So that I think it doesn't, post legalization. It's not just fear. I think you get a balance of stories coming through, but it is something that you need to attend to,
Thank you. Liz Saville-Roberts.
Question I wanted to ask, just been asked, but led me to another, which is to Dr. Naomi Richards. And it seems that much of what we're discussing assumes that being patient-centric is intrinsic actually runs day to day through medical culture. Is that actually the case in your experience? And is there something that within the culture that needs to change in order to become more patient-centric, in order to enable autonomy?
I think you probably know the answer is it's not patient-centric. So Marie Curie's Better End-of-Life Care report from last year found that it was a representational survey with bereaved relatives, and a third of people didn't think that their relative knew they were even dying. So we've still got a long way to go in communicating to people that they are in a terminal phase, so that they can find whatever residual value is in that period of time for themselves and their family. So I think no, definitely not, but that is what we are striving for. I'm sure that's what all healthcare professionals are striving for. But in terms of assisted dying, it would be so explicit. It's much more. I think it's categorically different from other kinds of conversations that are much more open-ended. Like goals of care conversations at end of life. This is really quite specific to the extent that you can actually give doctors a form of words to use, because you have to. It just has to be so that their request for this procedure has to be so categorical, and there needs to be no ambiguity around that. So in a way, this conversation about assisted dying is actually different, because it's very upfront. It has to be very categorical. It has to be documented. So in that sense, it is extremely patient-centric, and there would be no kind of using euphemisms, which happens in end-of-life care. So what doctors think they've told their patients, they do not hear. They've heard something else, because euphemisms change according to, you don't even have to go so far as to talk about different communities or cultural groups, they just from one person to another. So I think this would require quite specific language. It would bring things into a much less ambiguous kind of territory.
Julian Campbell. Thank you, Chair. My question is to Professor Preston, and I'm just going to go back on something that you said in your last answer, where we talked about issues on how people are treated and the differences and inequalities that happen across society, but also within our healthcare systems, and how things are done. And we know that this was highlighted specifically during the pandemic. My question to you is, how do you think these inequalities will undermine the principles of this bill?
I think it's about having that additional consideration. And I think when additional consideration for perhaps social deprivation, for about people from minoritized groups, is in the training and is at the forefront of people's thinking, then they can address this. So I'll give you an example. We did a study looking at access to palliative care, and I know you've heard a lot about the Surreal postcode lottery and things like that. One of our areas is one of the most deprived coastal communities in the country, and yet it had equal access for people across all areas of society, because they brought in people to target anyone from those socially deprived areas. Equally, at the beginning of the first wave of the pandemic, one of the big London hospitals, we analysed the data because we were concerned about access to palliative care services. Were people accessing it during the pandemic? We also looked by ethnicity. And what we found was not only during the pandemic, but pre-pandemic, if you were non-white, it took, 3-5 days longer to get that referral. Now, we had an idea that from some of the research we'd done on social deprivation, that people are making assumptions. So again, it's not about people making horrible decisions, but they're making assumptions. Oh, they'll have a big family, the family will look after them, this will happen, that will happen. And the nurse consultant, Claude Chiliac, he went in and he did training to the staff and said, don't assume that just because people come from, Afro-Caribbean families, something like that. They've got this big family, and literally within a year, when on the second wave happened, the difference had gone. So I think if you can put it forefront in the training and make people really think about it. But I would say, I think someone said it yesterday, there's almost an inverse inequality, because I think those families and those communities will be really trying to protect people from even thinking about going for it.
Daniel Francis.
Thank you, Chair. My question is for Claire Williams and follows on from Dr. Offer's question. So, Clause 18, subsection 9, does talk about that the person that's self-administered the approved substance, the doctor must stay with them until they've died, or until it's been determined by the coordinating doctor that the procedure has failed. We know from overseas, in a very small number of cases, that procedure may take 3 or 4 days. In some cases, so clearly the doctor can't stay with them the whole time. But in subsection 10, it then says, of course, the doctor need not be in the same room as the person to whom the assistance is provided. So I just wanted to understand, in terms of safeguarding, how that could be strengthened, really, because clearly, while it says the doctor must stay with them, clearly it's not practical for the doctor to stay with them for a number of days, number one. But number two, it also then goes on to say the doctor need not be in the same room as them.
Again, I can only apologise, as my evidence really here is around talking around committee-based panel approach to decision-making, rather than actually what happens at that point of end of life. I don't know if there's somebody else that would be able to comment.
Yeah, okay. Professor Preston, thank you very much, sir. Thank you. Sorry, if you're agreeable, Chair. Sorry. Yeah, sorry, I apologise.
So I think that's an issue we raised about the concern about doctors staying with people for prolonged periods of time, and I think it's going to come down what does self-administered mean. And I put in our written evidence in Switzerland that's increasingly being setting up an IV drip and the patient opens the port, in which case you're talking about different drugs and it would be much speedier. But if you use the oral ingestion, which we got the data from Oregon, and I think it's 30% of cases took an hour to die. Now, I think most of us know within the NHS an hour with the doctor is going to be pretty unlikely, even if they're in another room. Most assisted deaths across the world occur in the home or a nursing home, so you don't have doctors there, talking about GPs being out for prolonged periods of time. So the method of administration may change that as well. But I suppose the other thing I'd just say with that is doctors aren't used to being with patients at the end of life. It's nurses and healthcare assistants. So you're actually bringing in a new role for them to be with someone as they die. Now, I'm not saying they haven't had that experience, but they're not the traditional healthcare workers who are at the bedside. So again, that would need to be counted in their training so that they're more used to being around people who are dying at the end of life. They will have had some, but it really is very much in the realm of healthcare assistants and nurses.
Simon Over.
I think that's been actually covered by my colleague across the way. Yeah, no, I was just concerned about. Well, I just wanted to be sure that we were secure if the doctor wasn't in the room. So I think that's been answered. Thank you, Chair.
Nasha.
Thank you. My question is really to Dr. Richards. When you talk about, and I will get to the position where I need to get to, so just bear with me. When you talk about this being a very explicit conversation, that I'd argue back that that's not entirely true, is it? Because we're talking about a set of doctors who will have opted in to have this conversation. Not all doctors will do that. We've also had evidence from people to suggest that actually doctors and not lots of people, if this was provided on the NHS, they would actually leave hospice care. We had hospice providers yesterday telling us that, or care providers saying that people, if they engaged in providing voluntary assisted death, they would leave those hospices. So it's not quite as explicit as what you're suggesting, is it?
I mean, yes, it would have to be. Those examples that you've just given wouldn't mean that it wasn't an explicit conversation.
But it's not, because it... Sorry.
One question, one answer. Danny Kruger.
Aren't finished? Okay, thank you very much, Chair. I just wondered, Professor Preston, what you think of this idea about a panel instead of the High Court judge. I think a lot of members who voted this through at second reading did so partly on the basis there would be this judicial stage. And while we can all recognise the value of having more expertise involved, the role of the judge is, in principle, and I think what the public would expect it to be, essentially adversarial. It would be hearing arguments. It would be taking evidence. So do you think without that, this bill would be safe? And secondly, do you not agree that, as we heard earlier from a law professor, the right of appeal should be in both directions? There should be the right of an appeal against an approval as well as against a denial.
I think we suggested a panel. I submitted some evidence after the last select committees talking about this panel that could operate outside, and for lots of it was the other reasons I gave, which was about helping navigate, helping identify doctors, helping support people who feel vulnerable within the NHS. I think what's increasingly coming out with the idea of a judge is what quite is their role, and I think there's a bit of a question for them within that, and there isn't the right of appeal. Whereas if you had a panel, this would give a much more thorough understanding of what is happening, and I think the additional safeguard is that panel could say there needs to be a palliative care consultation. So the doctors who are doing it, you'd have to be sure from the register of them, they are qualified to have a palliative care conversation, so all options have been explored. My fear is if we don't really specify what training is or who these people's expertise are, you could get doctors who, most doctors really don't know too much about palliative care and really what the options are. You don't need to see a palliative care doctor, a palliative care nurse can talk you through it. But I think that's the additional power of that panel, but it could be answerable to the court or to some sort of other assisted dying tribunal.
Lewis Atkinson.
Thank you. A question for Dr. Richards, if I may. I note from your biography that you've done work studying the phenomenon of old age rational suicide. And I note your comments before about research suggesting that people that seek assisted death have got very particular strong preferences for control and agency at the end of life. We know that there's around 650 people with terminal illness that that take their own lives every year at the moment. I just wonder your assessment on if assisted dying becomes an option here in the UK, how that might interface with those statistics, and in particular, given the work on old age suicide that you've done.
Yeah. So. The bill that you have put forward is for terminal illness only, 6 months left to live, so this would not include the phenomenon of old age rational suicide, which is where you are wanting to end your own life for reasons of the accumulated losses of old age or because you feel that you've lived a completed life. This is really for people in what's called the fourth age of life, and it is a social, cultural phenomenon that there are people in the fourth age of life who want to wrap things up on their own terms. But this is a separate phenomenon, I would say, to people who are in a natural dying phase of life and want to accelerate that. So it's different. I think in terms of older people continuing to take their own life so you legalise assisted dying for terminal illness, you are still going to get older people taking their own life. In fact, the highest kind of demographic for completed suicides is people over the age of 70. It is a phenomenon around the world, but it's qualitatively a different phenomenon to people in a natural dying phase. And I did just want to add to, yes, if we look at the data on the people who request assisted dying, it is people who want control and agency, and they may have even sort of thought about this as a mode of dying that they want to access before they even had a terminal illness. They might have always imagined that. But that's in conjunction with various forms of suffering that they will be experiencing. So it's not just personal preference. They are also suffering, and suffering is very multifaceted, is multidimensional at end of life. So it has various different components, not just physical.
Before we move to the next panel, is there anyone else who has pressing questions, or would you prefer to have a 5-minute comfort break? I think Naz Shah and Kim, very quickly, and then we'll try for a 5-minute comfort break. Naz Shah.
Can I just ask again, Dr. Richards, you're talking about people, elderly people in particular, but we've heard evidence about, particularly yesterday, about young women under the age of 40, where anorexia was deemed legislative to be applicable to this, what would be a terminal illness, and that's quite a phenomenon as well, it appears. So that wouldn't be as, when we're talking about this explicit conversation that you're suggesting, I would argue that's not necessarily clear-cut, is it? That there would do you agree there would be a risk there when it comes to people with anorexia?
I don't really understand why the case of terminal anorexia would be different to any other, case in terms of the conversation. It would be necessary to have a very explicit conversation with somebody who is requesting assisted death. It doesn't matter what their illness is. On the issue of anorexia, I do think this is slightly, the numbers are just really tiny. So in the Oregon model, which is what's in this bill, you're talking 1 or 2 people in the history of assisted dying. It's like a very sort of minor kind of issue to get focused on. I've seen so much about this in the press and discussed here, and this is really not what we're actually. If you're very concerned about terminal anorexia, I'm sure that there's some tinkering you can do with the bill so that people would not be eligible for assisted dying. But in terms of the empirical data in jurisdictions that have legalized the Oregon model, which is what this is, there is 1 or 2 cases. This is not something that should be given a huge amount of time, because it's a distraction from the fact that really what we're talking about is a new mode of dying, which is a response. It's a cultural response. Just as palliative care is a cultural response to suffering at end of life, so is assisted dying. It's a different track. It's offering something different. Different types of people are going to want to go for that. And it's a response to the protracted dying trajectories that we see now, which is new in the history of human dying. We've never taken so long to die before. There's never been so much medical intervention at the end of life, and assisted dying is a cultural response to that. And to get fixated on the 2 people with terminal anorexia who've accessed assisted dying in the States is a bit of a red herring, I think.
Thank you. Kim, last question, quickly.
Yeah, very quick question. You talked about nurses. I think that was you, Professor Preston. Again, feeding into this multidisciplinary approach, one thing I'm really clear about is that we have to have the best training in the world, I think, around those end-of-life conversation and end-of-life choice. So if you've got any thoughts about what that training could look like, what the important components of that would be, I'd be interested to know those, maybe starting with you, Professor Preston.
Yeah, I think we've heard lots of evidence about training schemes around the world, and I think, to be honest, I think they are still developing. But I think we can look at what are the good elements of that, what has been evaluated, what hasn't been evaluated. I think we need to have a sort of, you can do it sort of like almost like an action research. You're learning as you go, and we can improve the training as we go. What we're not very good at the moment, and most people don't die under palliative care. Most people, this bill will affect general care, it will affect specialist care, but not in palliative care. We need to train those people as well, because they will be having a lot of these conversations. We're doing that training now, which is about how do you talk to someone in a compassionate way? How do you help people to understand they can be involved in their decision making? What might goals of care for you be, and what might a goals of care conversation look like? So we've got lots of this training already. Palliative care has huge expertise in this, advanced care planning, the rest of it. So So it's just about getting some of that incorporated into this. It's not just about this is what an assisted death would look like, this is how it would process. It's got to be more than that, and we need to help people explore their end-of-life choices. So how do you want to die? Do you want to die at home? Do you want the cat on the bed? It's all those really things that are really important to people. But unless we have that conversation, explore them, and it's quite hard to get clinicians to have them, this is going to be a special group of people who can manage this. They'll need training and they'll need support.
Thank you. Can I thank the witnesses on behalf of the committee? And we will adjourn until 3 p.m, which gives us 6 minutes. We will now hear oral evidence from people and families of those with relevant experience. Liz Reid, Pat Malone and Julie Thineport, who is on Zoom, but I'm afraid we've lost her for the time being, but we are trying to get her back. Thank you very much. I'm going to start with Kit Malthouse. No, I'm not. I'm going to ask you to introduce yourselves.
My name's Pat Malone, and 3 members of my family have died in dreadful circumstances, 2 of them by suicide, and I think the circumstances of their deaths would be useful for the committee to know before any decisions are made.
And I'm Liz Reid. My brother had an assisted death in a hospice in Queensland in Australia. Their law is very, very similar to the bill, the assessments, the focus on coercion. So I'm here to share how the law works in practice for a dying person and their family.
And we still haven't got our Zoom, so I am going to start now with Kit.
Thanks very much, Carolyn, and welcome. Liz and I, you have met, and I have met before. I'm very conscious that during the last couple of days of evidence, we've heard from all sorts of people, but not actually from anybody either with a terminal illness who's been through, or somebody who's been through the experience that you've been through. So, welcome to you. I mean, I guess my question is, we've heard quite a lot about the complexity of the issue that we're dealing with over the last 3 or 4 days, 2 days, 3 days. But we've also heard right at the start that we have to balance that against simplicity and access and speed. And I just wondered, from your experience of the 2 methods that have been used in Australia and also in Switzerland, whether you thought there was something to be learned from those systems about that balance.
I'm not familiar with the situation in Australia. My 2 suicides were all out with the law. And the third death I was going to talk about was a natural death. We would call it a natural death. So I'm sorry, I can't make a comparison.
Okay, yes.
The system in Australia, as I said, is quite similar to what's being proposed here. And it felt like throughout that process for my brother Rob, it was really caring, respectful. He was able to change his mind, which he did, in terms of dates and when it would happen. His views and the views of his family were also taken into account, and through the process he was treated like a person with autonomy whose choices were being respected.
Thank you. I can see that our third guest has actually appeared on screen, Julie Thineport. Welcome, Julie. Would you like to say a few words before we continue?
Just to introduce myself, I'm Julie Thineport, and I was living in Spain at the time. My husband and I were living in Spain. My husband was diagnosed with mesothelioma and given a 3 months, left to live sentence. So he opted for assisted dying. It was quite a rigorous process in Spain. It only came into the law there in 2021, and he was one of the very first people in the south of Spain to actually take the opportunity for assisted dying.
Thank you. Okay, so to continue with the questions, we will go to Tom Gordon.
Thank you, Chair. Thank you to you all coming here and sharing your personal experiences. I think it really adds to this, and this is why we're all here. The question that I've got is, one of the conversations surrounding this bill and this debate is about access, and about if we weren't to legislate now, we might not see another debate or bill brought forward for potentially a decade or longer. What's your views on that? Is this, I think some people sort of see it as a point where we either will progress or we won't. And do you feel that this needs to be a continuing and ongoing conversation, particularly in regards to palliative care and experiences that your loved ones might have had in that system?
So, as I said, my brother died in a hospice.
Yeah.
And it was in Australia. The hospices are extremely well funded, and the care he had was sensational, and the team and the staff in that hospice made the time he had in there. Obviously, it's not amazing because he was dying, but for a really difficult situation, it was comfortable for his family. He had young children, the care, the access to the medication, etc. You could not fault that. And so his care, and we as a family, after he died, actually went back to the hospice to say this was changing for us and for him. But it didn't change what was happening to him. And so he actually went from a hospital to a hospice, had a date planned for his death, and then actually changed his mind and extended it because it was better than being in a hospital and the hospice care was great. But he still landed at the same point that this isn't living, and it's not what he wanted, So I think from a personal perspective, whenever he was diagnosed, we said, you've got to come home. But actually I just think, oh my God, what would have happened to him? How long would he have had to go on? How long would his children have had to watch him? You know, he was only 39. His children were young. And actually they didn't have to. They still remember their dad. And so for us, for him and for his wife and our family, I wouldn't change anything.
Thank you. Lewis Atkinson.
Pat, if I can ask you, the draft bill that we've got as currently drafted, can I ask what, if this had been in place in the instance of your family and the situation of that, can you tell us a bit about what difference that would have made to you and your family's experience?
In all three cases, it would have improved their lives and their deaths. My father died at the age of 85 from pancreatic cancer. He asked me to help him kill himself while he was in hospital in the last 3 weeks of his life. Obviously, I wasn't able to do so. He suggested I put poison in his water, which I had no idea how to action. I spoke to his consultant. I asked him if he could do anything to hasten his end, and he said, "Oh no, can't." And after that, he lasted another 3 weeks, and he had a horrendous death, and it scarred our family to this day. My brother contracted the same disease, pancreatic cancer, and having seen my father die, he, having gone to 6 doctors and asked them if they could help him end his life, and he was under home hospice palliative care at that time, he contrived his own suicide. Unfortunately, he asked his wife to sit and hold his hand while he died, as a result of which there was a police investigation into collusion, and she and her daughter, who was also in the house at the time, weren't cleared for 8 months, during which time they were interviewed repeatedly about anomalies and what they knew, what they didn't know. And that was absolutely unconscionable, to pile that on top of their grief at a time when they just lost their father and husband. My sister's death was, having seen both of those deaths, was much easier. She got motor neurone disease, and she wasn't really suffering in the way that they had been. She knew that her end was going to be as a live brain in a dead body, and that was the horror that she faced. And she, from the beginning, she was fixed on going to Dignitas, which she did. It wasn't easy because, with the example of my brother's family, she wouldn't allow anybody in her family to have anything to do with the arrangements she had to make. And the arrangements were quite complicated, and they became ever more difficult for her. Firstly, she couldn't drive a car anymore. She was going around on a mobility scooter, gathering all these endless documents and having all these tests that you need to have. But ultimately, she said, this is my golden ticket. When she was accepted, she said it was the greatest relief of her life by Dignitas. She said, I know I'm not going to get cancer, I'm not going to get dementia, I'm going to die painlessly at a time of my choosing, in a place of my choosing, which is exactly what she did. But she died 1,000 miles from home. She should have died in her house with her family and had dogs on the bed. And she shouldn't have been denied that. And had this legislation been in place, had this bill been enacted in her time, it would have been a much easier operation. I think the problem with this legislation mainly is it's so far overdue. I think there are people now who are in that position And having been in that position, there are many, you may think our family is star-crossed, that we've had 3 deaths like that, but in fact I think we're just a normal family. It's happening all the time, and all this, Chris Whitty was talking on Monday about how we shouldn't rush into this. We're not rushing into it. We're at the back of the queue, really. Anyway, I'm rambling now.
Thank you. And thank you all for sharing your family stories today. It's really quite moving already. Maybe if I can go to Julie, about your experience in Spain and how you found that, particularly going through a particular process in comparison to maybe what we have in the law, the draft law bill here we have. How did it work, and what was positive or difficult for you?
Okay, so Guido had decided right from the word go, from even before he ever got sick, that would be the way he would want to end his life if there was a possibility of it. He was from Belgium originally, so expressed a wish that if ever he needed it, that he would like to go back there. But the law, the actual law in Spain is very similar to the bill, because I've read through the bill countless times, and there's a lot of similarities. It was very rigorous checks. It involved much paperwork, counselling, family liaisons. The difference being that it went before a board. So it was a panel that helped, that allowed or not the decision. Whereas, it wasn't decided in a court. So that would be the main difference. But it was rigorous and slightly difficult for me because although I can speak Spanish, obviously the terminology that was being spoken about quite frequently was more difficult. So that they had to translate very kindly to me and explained everything, what would happen, how it would happen, if it happened. And yeah, it was a big celebration for Guy when he was actually granted that he could have this. They also told us that he was able to change his mind when he'd made the decision, should he wish to. He did once, which was on my turn. That was me that asked him to do that because I didn't feel he was sick enough, which sounds a bit silly, I know, but he was an intensely private person, and the palliative care in Spain is, in the part where we were, is excellent, but it was quite irrelevant for him because he'd already expressed he wanted to die at home. We lived up a mountain, we were quite remote, and so he did not want to share any being such a private person, he did never want to become in a situation where somebody else had to see him in any vulnerable situations, especially personal hygiene, etc. Even me, I was able to help him in many ways. I had to do a lot of procedures for him after being trained to do so. But he was more than happy with the situation of having the assisted dying once it was granted, and was quite, sort of didn't need any other sort of care. Although they did, we still had a nurse coming every few days, and the family doctor came up at least once a week, which doesn't sound much, but he didn't want her any more often than that.
Thank you.
Thank you very much. Question for Mr. Malone, and may I say how greatly I sympathise with what you've been through, and I'm very, very sorry to be fighting against you in this matter. I really can't imagine how that feels. So thank you for what you said. I just wanted to ask about your sister's experience, and particularly the eligibility question. Is it your belief that she would have qualified for an assisted death under this law? No. With the 6 months terminal illness, and just follow up to that, do you think that we should be potentially expanding the scope to include people with motor neuron disease who might not have fallen into the 6 months?
She would not qualify because there was no telling how long she would live as as she said, a live brain and a dead body. It could have been months, it could even have been years, so she wouldn't qualify in any case under this. However, you've moved mountains to get to this point, and the last thing in the world I'd want to do is pile more requirements on this bill. We need. I'd like to see some stuff stripped out of it actually to make it easier, but I'm not going to ask for that because we desperately need to get away from the status quo, and this bill gets us away from the status quo.
That's Sean.
Thank you. First of all, thank you very, very much for coming today and sharing your stories. I've got two questions. One for yourself, Julie. You talked about you had family liaison and you had counselling. How long did that go on for? And do you think, because this bill doesn't have that requirement, and do you think that is something that we should be having in this bill?
Okay, so I wouldn't, sorry, maybe I said counselling. It wasn't like a session of counselling. It was where somebody would actually ask my opinion and check that I was 100% behind Guy. His son did that also by proxy because, well, you know, via us because he was in a different part of Spain. But they wanted to ensure that he had talked it over with family members. It took. I mean, it wasn't hastened along because he'd been given a short sort of, you know, lifespan. So it didn't take totally long, but it was, first of all, he had to wait about, I think it was about 3 weeks before the initial ball started rolling. And then 2 weeks later, we had family doctor and nurses from the hospital came round and also form filling, reading through, translating and signatures. And then again another 2 weeks after that, and each time I believe it went before a panel. We didn't, but the paperwork had to go before a panel. They were left in no uncertain terms that that was the way he did want to end his life. And if I could just say, it was a very peaceful, serene and beautiful death, as opposed to what it would have been like. We were able to, if I may say, he was able to speak to his relatives in Australia. He was able to speak to his brothers in Belgium and family members, and I was able to hold his hand. And Guy had always been, on a personal basis, he'd always been a bit of an old cowboy and always said he wanted to die with his boots on. I'm proud to say that's what he did. And he also, towards the end, well, at the end we were holding hands. I said to him, "Don't be afraid." He said, "I'm not afraid." And he winked at me just before he closed his eyes. The process, I perhaps should have said as well, was not, it was intravenous. So he had a drip in each arm. So it was quite a quick process, maybe 10 to 15 minutes, which I thought was quite quick, but we'd had, you know, sort of lots of time that morning, and, you know, it was a beautiful end, the wink especially.
Thank
so I'm left with very good memories of such a peaceful death that was going to happen regardless, but that he was at peace with, so that helped me.
Thank you very much for sharing such personal experience. Can I please ask Liz? Liz, you talked about your brother and going over and how peaceful it was for you. We've heard lots of witnesses talking about people who have felt like a burden, and clearly I'm glad that wasn't the case with your brother's death. Would you support the more safeguards in this bill from what it is now, to make sure that we protect those that are at risk from coercion and that necessarily might not have the capacity?
I understand there's a big focus on coercion, and it's very similar in Australia. The actual difference with the Queensland specifically bill compared to what's proposed here is that coercion in that bill is punishable both ways. So you can, for trying to coerce someone into an assisted death, but also trying to change their mind the other way. And those safeguards are in place because anecdotally what you hear from practitioners is broadly people are being coerced out of this. In our experience, the day before my brother died, our mum said to him, "Are you sure?" She was not trying to coerce him, but was she trying to make him go on longer? Absolutely. And that's her son. And that's completely natural and normal. She didn't want to see him die. And his response was, "This isn't living."
Thank you. Thank you very much.
Can I just say that as far as my brother and sister were concerned, there was no check for coercion. There needs to be, as in this bill, but there are much more safeguards in the bill than there are now. The people who are contemplating suicide now have no safeguards at all.
Thank you.
Dr. Simon Orfer.
A brief question, really, particularly for Liz, and can I have another one after that, or just one?
Just one for now.
Okay, all right, thank you. So I'm being greedy there. But you were, Liz, you were saying about sort of excellent palliative care. What was the reasons, do you think, your brother wanted to end his life? Because he sounded like, he didn't sound as though he was particularly depressed, would you say?
No, he absolutely wasn't depressed.
And he was having excellent palliative care. So what was in his mind, do you think? Why did he decide on that option?
He knew he was dying. His health, he was diagnosed in October 2022. And by April, May, and just to be clear, in that period of time before his health started to really deteriorate, he had a great time. He went fishing, he went to the beach. It was like an advert for Australia, how great his time was. He quit his job, was with his young sons. He had a lovely time. But his treatment stopped working. He had had every treatment, and even though he was on the pathway and had started the voluntary assisted dying process, he was still having immunotherapy. He wanted to live. His family wanted him to live. But he got to the point where he knew he was absolutely not going to live, and it was a matter of time. And what he said he was afraid of was not dying, but dying in an awful way. He was worried his lungs were filling up with fluid. He thought he might have a heart attack. He was afraid of that happening. He wasn't afraid of dying. And so for him, he wasn't depressed, but he knew what was coming, and he felt like in his own words, "I'm just sitting here waiting to die." And he'd had experience of a friend whose wife had died, and she got so bad that her young son couldn't visit her anymore because it was too frightening for him. And, his children remember who he was, this big 6'6", rugby-playing, fun dad. And he got to choose, actually, I'm ill enough, I'm frightened of what might come down, which I know is going to happen anyway, and I choose now.
Thank you.
Kim Ledbetter.
Thank you, Chair. Thank you to you three witnesses for coming this afternoon and telling your stories. I know how hard it is to tell your story over and over again, and I think it's really important to reflect on the fact we've had a lot of talk this week about amendments and clauses and various other technical details, but actually this is the reality of the subject that we're talking about. So thank you so much for sharing your stories. I think it maybe for Liz and for Julie, it'd be interesting to know any aspects of the process that you went through, both in Australia and in Spain, that you think could have been done better, could have been improved. Is there anything from your experience that we could learn from to enhance what we're trying to do here? And I think for all three of you, and Patrick, I mean, goodness me, to come here and tell your story after everything you've been through is unbelievably brave, so thank you. But what impact did these different types of death have in terms of on your grief and on bereavement? I think, because that's what we're talking about. We're talking about different types of death. So to think about what that looks like for people, I think will be really quite helpful as well. Do you want to start? Should we start with you, Julie, if we can, Chair?
Yes, certainly. It's a very good question, actually, because I think it did impact my grief, not least because there isn't anything I would change for definite about that. But I think I mentioned before about I'd not tried to talk Guy out of it the first time round, but I did say, don't be so hasty, because you're not as sick as you could be. I was, he was still getting up and dressed every day and, managing pain. So we had that discussion, but on he had the only day that I ever knew him to stay in bed a little bit longer. And that day I knew he was thinking about phoning to say that he was ready. And he called me to him. He said, come sit with me. He said, I want to ask you two things. He said, the main one, which is relevant to this, is don't try and talk me out of it this time. I've made the decision. Don't try and talk me out of it, because I don't want you to be impacted in that way. And the second one was to be strong. And both of those have impacted my grief, because I was so strong. I was so strong for 12 whole months. And I just thought, yes, we've gone through that. It's been great, and it was not great. I'm sorry, I'm using the wrong terminology, but for me, it was so good to know that he died so peacefully, and he was at peace with himself. And that happened, and I thought, right, now I've got to do the be strong bit. So I did that, and I did want to talk him out of it again, but I didn't. And I was very strong, and then all of a sudden one day it all sort of, grief did start to creep in, obviously, because suddenly I thought, hang on, he's not coming back, So that's a normal grieving process, but it held off a little while. And when the pathway that the grief that I experienced took was every day I had a different memory of us sitting somewhere, being somewhere, doing something. The last months that we had together, knowing that he was going to die, our, sorry to sound like a bit of a romantic, but our love intensified so much, because you know that everything you do is probably going to be the last time you do it. And there's this almost like an unbreakable bond between you, that you're both in this situation together, and you're going to get through it, and you're going to be strong, and you're going to be there for each other. And I think that carried me so far, because those 3-4 months that he lived were the best 4 months in the sense of our closeness, and how supportive and how caring we were for each other, I think. So it makes me smile now. When I think of his passing, I smile, rather than, yes, I do get upset, and I miss him a big lot, but I smile, because everything was worked out the way he wanted it to.
Thank you so much.
Okay.
My experience was entirely different with my father, who, my daughter, who was 7 at the time, reminded me recently, when I put my thoughts together for this, that in his last week she had visited him, and I had taken her aside in a side room and told her not to expect to see the grandpa that she knew, because he was very, very ill and he didn't look anything like she would expect. And she said she was very thankful that I did that, because she was stunned and shocked when she saw him. He was like 100-year-old, 1,000-year-old corpse, and he was moving, and his eyes were yellow, and that's how she remembers him. She doesn't remember any of the good times. My sister, who lived close by, was with him most of the time, and she just sat by his bed and prayed for his heart to stop. And we were all shell-shocked when he did finally die. And as I say, that informed the decisions that were made about suicide by my sister and brother. Had he been a farm animal, we would have been prosecuted for causing unnecessary suffering. But he was a man, so he wasn't entitled to that sort of consideration. And I remember him in that horrible ward, breathing his last. I remember the only time he moved in the last days was to cough up blood. And for a man who had asked to be relieved of that burden, for an act of mercy a week before, and it had been denied him, I can't understand how anybody would deny a dying man a deliverance. So when my brother died, of course, my sister-in-law, they'd been together since they were 11 years old. He was only 53. They'd already known each other for 40 years. She had shared his suffering while he was being driven around the country looking for diagnoses and ultimately looking for doctors who would help him commit suicide. His weight had gone from 18 stone to 8 stone, and he was bright yellow as well, and he was suffering all the time, and she was suffering with him. And she was relieved as well as grieving when he actually died, and then the police were at the door. And that investigation went on until his inquest, 8 months later, and it was the police were as helpful and as sensitive as they could possibly be. And Vicky got the impression that they wanted her to give the wrong answer. Like, did you know what he was going to do? Yes, I did. Could you have stopped him? Yes, he was as weak as a kitten. Could you have resuscitated him? Yes, she'd had some nursing training and so forth. And every question, every answer, so they just collapsed a little bit more. But ultimately, at the inquest, there was an anomaly in his suicide note. It was written in 2 different colours of ink. And the police investigated whether it could have been written at different times, possibly by different people. And giving evidence at his inquest, the police said, well, no, they thought his pen had run out. There was a squiggle at the top where it changed from black to blue. And they thought it was just a matter. And they said that they weren't proceeding with any idea that there had been positive involvement in his suicide. And I think I've got a note of the transcript of what the coroner said, which is, I don't want to make any more of this than I absolutely have to. I simply record, therefore, that Michael Malone took his own life. He did so quite deliberately and having made appropriate preparations. And so it's not a case of my saying that he did so while the balance of his mind was disturbed, because it clearly was not. It was a decision that he took, and I have every sympathy with that decision insofar as a coroner is allowed to say that. The police were very sympathetic. The coroner was very sympathetic. Danny Kruger is very sympathetic. But sympathy only goes so far. And I'm glad that this committee is now looking exactly at the people who matter in this issue, the people who matter first in this issue, who cannot be here to talk for themselves.
Liz?
In answer to the first point about anything that we would change or do differently, I think actually my brother his case was dealt with really well, and there were checks and balances along the whole way. So, does he meet the eligibility criteria? Obviously, but also, does he want to? His wife was involved in the process with him, and he was checked constantly. He actually, a doctor administered for him, and he had met him already. He had a rapport with him. He knew him. He had a few jokes with him at the end. So from that perspective, I don't think so. It's slightly different there in the sense that it doesn't have to have a High Court judge, so the process feels probably in Australia a little bit more streamlined than it is here. And maybe the access will be slightly different because of that. And in terms of the grief, I think anyone that knows that's been through someone with a terminal illness, there's a level of anticipatory grief that comes with that. The waking up every morning, has it been tonight? What's happened next? What's today? Because when someone is in the final stages of their life, which my brother was, there's always something. Every day there's something. Oh, he's got to have fluid drained from his heart today, or, oh, this has happened, or there's always something. And so that grief starts coming on before even the person's died. And really like Julie's actually, the day my brother died, we sat outside in the courtyard, we had a glass of champagne. He chose a song he wanted to die to, Bob Dylan. And it was extremely peaceful. It was seconds. And he got to say all the things, have all the conversations, speak to our parents, that sort of real American closure. That's what he got. And everyone, we weren't sitting around there thinking, God, I wish I'd said this, and I missed it, or I was off doing something with the kids. We were all there. My mum, my dad, me, his wife. We sat there and held his hand. And actually, what a gift.
Yeah. Thank you. Absolutely. Sarah Onley.
Thank you, Chair. Thank you all for coming today and for sharing these really personal recollections. I've got one question but to both Liz and to Julie, if that's okay. According to the notes that I've got here, so apologies if I've got this wrong, but in both your brother's situation and your husband's situation, it was administered by the doctor. The bill that we have before us is proposing that the person who's made the choice about ending their life should self-administer a solution. Do you think, and I'm really sorry if this causes you any distress, but do you think that might have made a self-administration regime, would that have made a difference, do you think, on reflection? Maybe Liz first, if you don't mind.
I don't think so, no, I don't think it would have changed his mind. I think there's an element of, I'm someone who's real squeamish, so I probably wouldn't want to, because I'd be like, about all that kind of stuff, but it wouldn't have changed anything for him, no, absolutely not. But I think there's a comfort in having a doctor there and administering, and that this is going to go as it should, and there's a calm that comes with that.
Thank you. Julie, if you don't mind.
Yeah, I think Guy being intensely private, as I mentioned before, he would have preferred less people around him at the time, as in the people who were there. There were two nurses, the family doctor and the administering doctor. They sort of prepared the scene, put in the drips in, they had to put one in each arm, and they had to be there in order to witness the whole thing. He would have preferred to have been able to do it himself, but I don't think they impacted on it in a negative way that it was administered by somebody else.
Thank you. Thank you so much. Thank you.
I think you want to say something.
Yes, my sister died under the Swiss method, which meant self-administering a cup. And she had, obviously, motor neuron disease. She was losing slowly the use of her limbs. She went earlier than she needed to because she wanted to be sure to be able to swallow and to be able to lift her arm. She could have probably put it off for some months, an indeterminate period, but she died before she needed to, in order to be sure that she could self-administer.
So, the Chair's given me permission for a very quick follow-up, Pat, since you mentioned that. Are you saying that if it had been administered by a doctor, I'm really sorry to ask this, but do you think she would have chosen to have lived for a little bit longer?
I can't speak for her. There were many problems. Bizarrely, the last package of documents that she sent to Dignitas got caught up in the postal strike. And they're all irreplaceable original documents. I don't know if you remember around that time, this was winter of 22, 23. There was a postal strike and it particularly affected international mail. And for 9 weeks, the documents were held up in a sorting office and they couldn't find them. And she was getting more and more concerned because her horror was that she would miss that deadline. Mm-hmm. And in actual fact, Dignitas agreed that in the final analysis, she could hand carry the last of the documents she needed when she came to Switzerland, and she was still able. But her horror when she thought she was going to miss the bus, well, it was quite palpable.
Thank you.
Yes, if a doctor had been able to do it, he might well have chosen that option.
Thank you. Thanks for answering that.
Dr. Simon Olfer.
I've been really fascinated by this, so thank you, all of you, for this. And what it strikes me is we've spent a number of days looking at, if you like, the other end of this, which is around coercion and capacity and that sort of thing. And I am concerned that we had a judge with Parkinson's who wouldn't be allowed through this act, and again your sister with MND. And so I just think we should consider it as a committee whether there is any amendments around these things and also around self-administration. So I just wondered whether you thought we should widen the Act and what your thoughts are. I presume you've read some of it at least. So, yeah.
As I mentioned to Mr. Kruger, I am loath to meddle in any way with the bill. I think the bill as it is the best we could do at this time. And I think it...
Mr. Moore, let me just say, I'm going to leave you continue, but that is out of scope.
Right.
That question is out of scope, but I leave you have your opinion.
Yeah.
Do you want to, if there's anything else you want to say?
Yeah, I've said really that as far as the meddling with the bill is concerned, I would like to see it passed as it is without too much delay.
Lewis Atkinson.
Another question from Mr Malone, if I may. The bill as it's drafted talks about the commencement period and how quickly this would commence in the UK if Parliament passed it. There's been some suggestions that we should delay the commencement in order, for example, for improvements to palliative care or other such things to be made. I wonder if you could speak to your experience on that and your opinion on that.
I think both my sister and brother had more than adequate palliative care. My sister particularly, she was taken under the wing of the Macmillan nurses, even though she didn't have cancer, and they were absolutely marvellous. Her GP was brilliant as well, behind her all the way for the whole year. She couldn't really have done it without her. The NHS was excellent. In fact, she was being used as a diagnostic tool or a diagnostic test by NHS surgeons who were teaching medical students to recognise certain... she would be put in front of medical students and they would be asked what was wrong with her. And of course, given that MND normally is associated with young men with brain trauma and so forth, it encouraged them to widen their appreciation of these diseases. But it meant that she met NHS specialists at a particular level, and they were... she really wanted for nothing. She had a stair lift put in her house in short order. She had the mobility scooters and all the gym cracks you have in your bathroom to help you get out of the bath and so forth. And above all, from the Macmillan nurses in Blythe, she had moral support. These are no-nonsense people who will walk through a wall if there's something that you need. And that's wonderful to have. So there was no palliative care issue with her. She never needed any pain control. She had everything she needed. It didn't change her mind one bit. I don't think... I would like to see palliative care divorced from the idea of assisted dying. What she needed was assistance to die. What my brother needed was assistance to die. They didn't... palliative care was a side issue. It obviously comes into it, but if you could look at assisted dying on its own, I think that would be useful.
Questions?
Would it be okay if I just say something?
Yeah, of course
on that?
it will. Please do.
Only this, and of course it is hearsay, but I live in Guernsey now, and being a small island, we know a lot of people know each other. I had something published in the Guernsey Press one day, fairly recently, and a friend of mine had a relative in the local hospice, which is excellent. It's absolutely beautiful, excellent, and the palliative care there and the teams are absolutely second to none. However, the relative of hers that was in there actually saw the paper at the newspaper and said, "Oh my goodness, I wish this bill would come to pass here, and I wish it would have been in time for me." He said, "I'm getting excellent treatment, but I'm sitting here waiting to die, and my family are coming every day to watch me wait to die." And he lived for 5 more days, and he actually expressed that, that even though his care was excellent, he really wanted to die sooner on his own terms.
Thank you, Julie. Kit Malthouse.
We've heard a lot, or we've discussed a lot in evidence over the last 2 or 3 days, this issue of how the doctor should approach the initial conversation and whether doctors should be allowed to initiate a conversation about assisted dying. I realise that each of you has experienced this secondhand, but could you talk a little bit about how those conversations were handled and whether you have a view about the ability of doctors, if this bill should pass, to raise assisted dying as an option for people who are facing this kind of decision? Perhaps, Liz, you could talk a little bit about the experience in Australia.
So Rob's experience was that this law actually only came in Queensland in January 2023, so post his diagnosis. But it was an issue that had been in the press. He knew this was coming in, and from diagnosis, he thought it was something he may consider. So I think he approached his doctor with that. In terms of my view on should doctors bring this up, I mean, we're coming from a position of privilege where, you know, we've access to media, and he knew this was going on, and I'm sure there'll be plenty of people that don't know. But I don't really know, to be honest, where I sit on that, because you know, for our family and for my brother, it was absolutely the right thing to do. So I can't really answer.
Okay, thanks.
I think some regulation and some guidance wouldn't go amiss. My sister had fantastic support from her GP. She did a lot of extra work to meet the requirements of Dignitas. And my brother had exactly the opposite. When he went to his GP, for a long time he said, oh, it's just indigestion, try Gaviscon. Even when he went to him in the light of his understanding of my father's death, to say, I think I've got pancreatic cancer, he said, oh no, it's not, it's just indigestion, and so forth. And it wouldn't have mattered. An early diagnosis would have made no difference at all. But the GP was not very helpful. He didn't want to get involved. When my brother died, my sister-in-law called the GP, and the GP called the police. And I think before my brother was called, the investigation started. So if there was some way you could actually say to doctors, this is what you can do, this is what you can't do. If you don't want to get involved, leave it to somebody who does, because there are plenty of people who will. And if that could be quantified somehow by a code of conduct, perhaps among the doctors rather than in the bill, I think that would be very useful.
Very good. And Julie, you said that you got to a point where he said to you he'd made his mind up, and that he didn't want to do. Had he made his mind up after conversations with doctors about what his options were?
No, he made up his mind long before he was even sick.
Right.
He always said that he felt his mother had quite a traumatic passing, and he said that she expressed a view that if that had been an option, she would have taken that, and he had said from then, that's the way I want to die. I want to die that way. I don't want to be lingering in a bed whether I'm in pain or not. I don't want that to happen. It may not be something that I would choose, but that was his absolute choice, and I have no doubt whatsoever that, well, he said to the team that had been looking after him when he first broached the subject, and they first of all thought he wasn't terribly serious, and then when they realised he was, he said, it's my life, it's my death, I want to choose. And I think that's what it's all about, is allowing people that option to choose.
Thank you.
I just wondered if you'd been on your own journeys around your personal views around assisted dying and choice at the end of life. Because, I mean, certainly I've spoken to lots and lots of people about this, and I think anybody who has had similar experiences to you are very clear that the law needs to change. People who haven't been as close to this issue as you have often hold a different view. So I don't know if prior to your personal experience you had a different view, or you might have friends or family who have different views, but I think for me, speaking to people who've had the experiences you've had, it becomes very clear to me that we've got problems with the law as it stands, or the lack of law as it stands. I don't know if anyone wants to share their own journey about that.
From my standpoint, I didn't give it a lot of thought until it started impacting on the family. But I understood exactly why my sister committed suicide and my brother, and I would hope that this bill could be enacted when my turn comes.
I actually hadn't given it a huge amount of thought. I mean, I'm relatively young, and I suppose if I was asked at the time, I would have said, yep, sounds fine, but I think also had grossly misunderstood what it would mean for someone to go to Dignitas. I think there's a flippant comment that goes around, oh, I remember my dad saying it, oh, I'll just go to Switzerland. And it's just not that easy. And people I know, like Pat, who I've met, who have had family members go to Dignitas, that's actually a deeply traumatising experience. People's lives are cut much shorter, they can't enjoy their time, etc. So, yeah, I absolutely agree that I hadn't given it much thought. But the day my brother died, I remember getting back to where we were staying, and I sat there and I thought, what would have happened? What would have happened to him? And I wrote to my MP, just sort of being like, hello, just wondering what would have happened out of interest. And that's how I got involved, because I just could not believe that had he have been here, what would have happened to him, and how long would he have had to have limped on. And there's enough people, you hear enough stories of people begging to die at the end of their life, that I'm really thankful that he didn't have to.
And if there are no further questions, can I offer the three of you the collective condolences of everybody on the committee, and thank you for your bravery in attending today and for speaking to us. Thank you very much. Thank you. Okay. I leave you. Thank you. Okay. I'm going to go through that again. Provide him gun. Does he know when to raise it? We got enough of us sitting down?
You need C7, so yes.
Okay. Thank you. If I could just call us all to order. Thank you very much. We will now hear oral evidence from Professor Emyr. Sorry? Okay, we will now hear evidence from Professor Emyr, Emeritus Professor at the Department of Law and Criminology, University of Aberystwyth, Dr. Michael Mulholland, Honorary Secretary at the Royal College of General Practitioners, and Dr. Annabel Price from the Royal College of Physicians. Can't get my words out. And Dan Scorcher, Head of Policy, Public Affairs, Information Advice on Mencap. Could the witnesses please introduce themselves so we can know who you are before you start talking? Should we start from the left?
Hi, I'm Dan Scorer from Mencap, the learning disability charity. So we work across England, Wales and Northern Ireland. We support 4,000 people with learning disability with their care and support needs, as well as providing information and advice services across the 3 countries. We also campaign for better support for people with a learning disability and their families across health, social care, employment, social security and cost of living.
Thank you.
Hi, I'm Michael Mulholland. I'm a GP in Buckinghamshire. I'm Honorary Secretary of the RCGP, and the Royal College of GPs is the professional membership body for general practitioners. We have 54,000 members across the UK. Our current position as a college is that we oppose a change in the law in terminally ill adults. And this was ratified by our council in 2020 when we last had a survey of the membership at that stage. Seeing that there was changes in the legislative landscape across the UK in 2023, our council asked that a group was convened to look at where our college should be going, and we created a committee that looked and created a list of principles that I will be referring to in any evidence I give today. We are currently undergoing a review in our council of what our position should be. We have a membership survey that is live at present, and we'll be bringing that to our council in March this year to decide the college's position.
Hello, I'm Emyr Lewis. I'm a lawyer from Aberystwyth University. I'm here to talk about legal and constitutional aspects relating to Wales which arise from this bill.
Good afternoon. My name's Dr. Annabel Price. I'm here representing the Royal College of Psychiatrists. It's a professional medical body responsible for supporting psychiatrists through their careers, through training, through to retirement, and I represent 21,000 members. In terms of myself, I'm an old age liaison psychiatrist. I work in a general hospital setting. I also provide psychiatry input to my local hospice, and I teach palliative care at the University of Cambridge. I have a research background in mental health at the end of life, and particularly mental capacity for terminally ill adults requesting assisted dying.
Thank you. Liz Saville-Roberts, Danny Kruger's kindly forfeited a question in order for you to have 2. So Liz Saville-Roberts.
Thank you very much to Mr. Kruger and to the Chair. The committee, I'm glad to say, appreciates, and this question is to Professor Lewis, that scrutiny is necessary for Wales-related aspects of this private members' bill. Could you tell us what the risks are of insufficient scrutiny?
Well, because it's a private members' bill, then it won't have gone through the process which a government bill would have gone, which impacts on Wales, of having the discussion between governments as to how this might be sorted out. So it's really important, and I am really grateful to the committee for having a session which focuses, albeit briefly, on Wales. Although this is an England and Wales bill, it is so because certain criminal offences are matters on which the Senedd in Cardiff cannot legislate, and that includes offences which relate to suicide. However, apart from that, the impact of this bill on devolved matters, if it became law, would be substantial on the health service in Wales, on social services in Wales, Welsh society generally. Therefore, it's important that you do take account of that. And indeed, there are certain aspects of this bill which seem to me to require a legislative consent motion to respect the Sewell Convention.
Could you expand somewhat on
thank you.
Which aspects those are?
As I'm sure you're aware, the Parliament here in London can legislate about anything at all, absolutely anything. However, in relation to where the power to legislate is given to the devolved legislatures, then the Sewell Convention states, and it's in the Government of Wales Act, section 176, I think, states that normally the Parliament in London will not legislate with regard to devolved matters. That's what's said. So there are certain aspects of this bill, I can give you detail, very brief detail on that, which, in my opinion, relate to devolved matters. The first one is Clause 32. This is a very broad clause which would give the Secretary of State very broad powers for the implementation of the bill within the NHS, including within the NHS in Wales. Seems to me unarguable that that is a matter on which both the Welsh Government ought to be consulted, but also which would require legislative consent from the Senedd. The second there's a sort of a cluster of clauses which impose specific functions on the Welsh ministers and on the Chief Medical Officer for Wales. They're clauses 31, 33 and 34. Once more, from a formal perspective, those seem to require a legislative consent motion. So some thought needs to be given as to how that might happen in the context of a private member's bill, it seems to me.
Thank you very much indeed.
Thank you. Sarah Green.
Thank you very much. Just to follow up on what you just said about legislative consent, if I may. In October last year, the Senedd voted against Julie Morgan's assisted dying motion. So I wanted to ask, in your opinion, what the implications that has on this bill and its progress.
So there was a motion put forward by Julie Morgan, which was supported by 3 or 4 members of the Senedd, which was broadly in support of this, well, not of this specific bill, but of the purpose of this bill. And it was defeated, as you say, after a full debate on the floor of the Senedd. Now, formally, legally and constitutionally, that is of no consequence, because it wasn't a legislative consent motion. And it, of course, as I said earlier, this Parliament is able to do what it likes. It could totally disregard that. Whether that would be a prudent thing to do or an appropriate thing to do, or even, one might say, a constitutionally appropriate thing to do is another matter. And I think it reinforces the point that, that there is a significance in making sure that this scrutiny of this bill has a Welsh focus. You might consider, for example, making different provision in Wales. You might, how do you respect what was a democratic vote in the Senedd in Cardiff? Well, you might consider, for example, and this is, I'm advocating this, is just an example of what you might do, having different commencement provisions. The commencement of the bill in Wales might happen in a different way if, on the assumption it was passed. So you might put that in the hands of Welsh ministers in the Senedd, just as an example. Does that answer your question?
Thank you, Chair.
Sarah Sackman.
Thank you, Chair. Just to be clear, I'm here as a government minister on this committee, and the government is entirely neutral on the bill, and so we don't take a position on the substance of the issues you've raised. But clearly the draft bill is intended to apply in both England and Wales, as you say, and your note is extremely helpful, if I might say so, in highlighting some of those issues which will be needed to be worked out. And as a government, we will work closely with the Welsh Government to assess the legalities and practicalities of any potential changes to the law. You've highlighted in particular how the distinctions between health law, which is a devolved matter, and the law of suicide, which currently isn't devolved. Can I just ask you, in relation to your written evidence, where you draw out on the first page clauses 32, 31, 33 and 34 in particular as issues that we should focus on in ironing out these legalities, is there anything else you want to add to that that you think that we as a government should focus on in our work consulting with the Senedd?
I think it is important that both governments understand how the implementation of what will be a pretty radical change in the law happens on the ground within the health service and within those who are responsible for delivering social services. Issues such as adult safeguarding, which in Wales has its own specific law and is slightly different from the arrangements in England. There's those kinds of nuances between the two territories, which I think it would be prudent to focus on. I also think that it is wise to bear in mind that Wales has certain statutory bodies whose interests might extend to this bill. For example, the Older People's Commissioner for Wales in particular, the Future Generations Commissioner as well. And I think it is important that there is some kind of forum, some kind of scope for those people also to be involved in how this is shaped.
Thank you. Thank you, Chair. Dr. Price, I'm really glad that we're able to have the Royal College of Psychiatrists in front of us today. Thank you for making the time. I just want to ask you about paragraph 11 of your written evidence. It is the Royal College of Psychologists' view that the Mental Capacity Act is not sufficient for the purposes of this bill. I wonder, could you expand a little bit on that? And if you feel able, can you make some recommendations as to what you think potentially could be sufficient?
Thank you. And in answering this, I'll also refer back to Professor Gareth Owen's oral submission as well, thinking about the purpose that the Mental Capacity Act was drawn up for, and that decisions around the ending of life was not one of the originally designed functions of it. So we would need to think carefully about how that would then translate into a decision which was specifically about the capacity to end one's life. We also need to think about how that would work in practice. When we're thinking about capacity assessments, it is usually related to a treatment or a choice around a treatment or a choice around somebody's life, for example, changing residence. And that psychiatrists and doctors and actually lots of professionals are very used to those sorts of decisions and have gathered a lot of knowledge and expertise and experience around it. This particular decision is something that actually we don't, in this country, have knowledge, expertise and experience in, and therefore we need to think about how that would look in practice. In terms of advice to the committee about what that might look like, I think that we need to gather what evidence we have, and it's actually very, very thin, from other jurisdictions that think about capacity as part of this process. So when I'm thinking about my PhD, I visited Oregon, and I talked to practitioners who were directly involved in these sorts of assessments. And they described the process, but they're not using the Mental Capacity Act as their framework. And they described a very interpersonal process which relied on a relationship with the patient. And the better a patient was known, the more a gut feeling type assessment was used. And so we would need to think here about whether that would be a sufficient sort of conversation to have. One of the things that I have thought quite a lot about is how can we really understand the workings of a mental capacity assessment? And one of the best ways we can do that is to see who is not permitted to access assisted suicide because of a lack of capacity. And what did that assessment show? We don't have data because those assessments for people who weren't permitted are not published. We can't read those. And so I would, if this becomes legislation, one of the suggestions that I have, and it's supported by the Royal College of Psychiatrists, is with patients' consent to record capacity assessments to see whether they meet the standard which is necessary. And I think it's important to set what is the standard necessary and what are the components needed to be confident about a mental capacity assessment. That will help both with standards, but will also help with training, because this is new territory for psychiatry, for medicine, and to be able to think about consistency and reliability, training needs to actually see a transparency in capacity assessments.
Thank you.
Thank you very much indeed. This is a question for Dan Scorer, please. I myself have worked with the learning disability charity My Life, My Choice, and done a lot of work with them on self-advocacy in the context of healthcare. And so really keen to hear about from you. We know there are excellent initiatives that do focus on supporting people with learning disabilities to engage with advanced care planning so that their preferences at the end of life can be respected. I just wondered if you could share some lessons learned from these, particularly in relation to giving people with learning disabilities a voice and an opportunity to talk about what matters to them at the end of life. And as part of that, what we could incorporate into the regulations that are being developed as part of the bill.
Thank you. So I think there are two kind of key concerns that I want to touch on. One was covered just at the end of the last session with the question about preliminary discussions. And certainly that's a key area that we have concern around how that initial conversation is initiated and structured. And that really leads into a conversation for us around rights to advocacy, that it would be extremely concerning if people with a learning disability who were terminally ill were not fully prepared and supported for that discussion. And for us, this links into the experiences that we had during the pandemic, which was touched on in yesterday's evidence session with Dr. Griffiths and others, where we had people with a learning disability who were being consulted with medical professionals about do not resuscitate or do not treat decisions, and were not being properly prepared or supported for those discussions. Indeed, in one of our own care services, we had someone we support who was called up by a GP and was asked, would she want the kiss of life? The GP was trying to explain it to her accessibly, and she said, no, of course not. I wouldn't want to be kissed by someone I don't know. And potentially, then a DNA CPR notice was put in place. So that example just shows the importance of actually preparing and supporting people for those discussions. And so we really would want to see a right to advocacy included within the bill to support people who are considering their end-of-life options. Just building also on the previous question around the adequacy of the Mental Capacity Act, I think there's also a question about the adequacy of training, awareness and compliance with the Mental Capacity Act now, and that's a huge issue that has been addressed, for example, through the Oliver McGowan mandatory training in learning disability and autism, which is rolling out across the NHS and social care services at the moment. But in addition to the MCA, we also need to make sure that clinicians fully understand the Equality Act, also the NHS Accessible Information Standard about rights to information and support for disabled patients. So in terms of Clause 5 on training, we would really want to see much more specificity there about the level of training that clinicians would be having around the Mental Capacity Act, and making sure that they're fully aware of their responsibilities to make reasonable adjustments for patients and to support them with understanding their choices around end-of-life care, which could include assisted dying.
Thank you.
Sanjan Joseph.
Thank you, Chair. I just want to come to you, Dr. Michael. In your the Royal College of Psychiatrists given a written statement, and it says mental disorders such as depression are more common in people nearing the end of their life, and delirium is more common as well. And hopelessness is very common with people with depression, and people's capacity and consent can be affected when they're going through this condition. And we heard about many evidences in the last few days about concern about capacity assessment, and also like Dan saying there should be a advocacy service available. So my question to you is, rather than the current model of 2 doctors and the court, if we have a panel with experts in that panel, we can look into psychosocial assessment and capacity. Would that make the bill stronger and more safeguarding will be brought into this bill?
Sorry, can I check whether it was a question for me at the Royal College of GPs or at the Royal College of Psychiatrists? Because I think it was maybe in their evidence.
Yeah, the evidence is from Royal College of Psychiatrists, but anybody can answer to that question. Yeah.
I think as GPs we feel that we need a standalone service to take people through this process for assisted dying. And we don't feel the GP is in the place to make an assessment of capacity for this process. It's something beyond anything of us have ever trained in or understood. We'll need people that are trained in assessing capacity at that point. As GPs, we're very used to assessing if somebody got capacity to take a course of antibiotics to be referred for something that we understand. But this is something that will require a much deeper level. And I think probably this College of Psychiatrists has thought more on that level at the next steps.
Thank you.
So, yes, to refer back to the written evidence, we think about people with palliative care needs in that towards the end of life, so the people who would qualify under this bill, around 20% of those people will have diagnosable depression. Around 10% of people will have a wish to hasten death, and around 4% will have a more persistent wish to hasten death. Those wishes may not be expressed unless they are assessed for, and that one of the things that I would do in my clinical practice would be to look for mental disorder, treatable mental disorder, in people who express a wish to hasten death. I don't do that alone. You asked about a panel. So when I'm thinking about the needs of people who are nearing the end of life, and I work with people nearing the end of life, most weeks of my working life, I work as a multidisciplinary team. So my own small team comprises doctors, nurses and occupational therapists, but I work closely with social workers, the safeguarding lead, I work with chaplains, I work with all of my medical and surgical colleagues to make good decisions about my patients, I think in a biological, psychological and social way, and not all difficulties that are psychological can be fixed with a psychiatric intervention. And so we would advocate as a college, and I would suggest as a clinician, that good decisions about our patients' needs are made in a multidisciplinary way, and that should be considered in the model of how to meet people's needs in whatever way they present, but particularly people who have difficulties and are suffering in a way that makes them feel that they don't want to continue living.
In the interest of trying to get everybody to ask their question, can I ask members to indicate which of the panel members they would like to answer, so that only one actually gives an answer and allows everybody to get in? Tom Gordon.
Thank you, Chair. I was just wondering, we've had a lot of conversations and had taken a lot of evidence over the last few days about whether or not a gag clause that might prohibit from medical professionals raising assisted dying as part of the options at end of life. We've heard from different states whether or not, in different jurisdictions, whether or not that's something that they had, or broadly speaking, the consensus was that it didn't seem to work. I just wondered if Dr. Mulholland or Dr. Price had any sort of comment on that.
Yeah, I think that's something that we've been thinking about carefully at the RCGP, that it is part of our normal discussion is to open it up for patients often to lead discussions around their end of life. We don't see... we see there could be potential restrictions if for that clinical consultation with a gag order if it was there. And we've very much followed the opinion I heard of Dr. Green from the BMA last week, or earlier in the week, and we go along with that. I think we're very protective as GPs of our relationship and want to give patients the options that they might want to choose for themselves. We're not pushing anyone to any decision usually, but supporting them through their end-of-life journey. And I think we'd want to protect that whatever way. So therefore, a service that we can signpost to would be the most appropriate thing we feel as the next step.
So as a psychiatrist and as a representative of the psychiatric profession, it's noted in the bill that mental disorder is a specific exclusion in the bill. So it's very unlikely that a psychiatrist would be suggesting or bringing up assisted suicide in a conversation, assisted dying, assisted suicide in a conversation. I think a concern which is allied to that is people with mental disorder who request assisted dying from their psychiatrist. And it may be clear to all that they don't meet eligibility criteria for that. However, what's not absolutely clear in the bill as it's written is to what extent would a psychiatrist have to comply with a wish for that person to progress to that first assessment. There's quite a lot involved in getting to that first official assessment, involving making a declaration, involving providing identification, for example. And therefore, a psychiatrist might have to be involved to quite an extent in supporting that person to get there, if that is their right and their wish, even though it may be clear to all that they do not meet eligibility criteria, if that is the primary reason for them asking to end their life.
Jack Abbott.
Thank you, Chair. My question was also for you, Dr. Price.
So the Royal College of Physicians has been really clear in their statements in saying that we as parliamentarians have to consider the outstanding questions about a person's capacity to decide to end their own life and whether it can be reliably assessed, and particularly with the implications of those with mental disorders, intellectual disabilities and neurodevelopmental conditions, I think you've cited in particular. So do you believe that anyone requesting assisted dying should be assessed automatically by a psychiatrist, and whether there should be a certain criteria that should be met? If not, that needs to be met. If there's a certain criteria that needs to be met if a psychiatric assessment is to be undertaken.
So if I take you to thinking about what an assessment of capacity would normally look like if we think about clinical practice, is that a psychiatrist would normally get involved in an assessment of capacity if the decision maker was unclear about whether that person could make a decision. And the psychiatrist's role in that capacity assessment would be looking for the presence of mental disorder, and if mental disorder was likely to be impacting on that person's decision making, and would advise the decision maker. And that the decision maker would then have the clinical role of then of thinking about that information and then assessing capacity with that in mind. So psychiatrists sometimes do assess capacity and make the determination, but it's usually about psychiatric intervention, about issues that are within their area of clinical expertise. So, for example, care and treatment, capacity assessment around the Mental Health Act, whether somebody is able to consent to their treatment. What I'm not absolutely clear about is, within this bill, whether the psychiatrist is considered to be a sort of primary decision maker about whether somebody should be eligible based on capacity, or whether their role is to advise the decision maker, who would be the primary doctor, or one of the two doctors. Should a psychiatrist be involved in every case? I think if there is a view that psychiatric disorder should be assessed for and ideally diagnosed or ruled out in every case, then a psychiatrist might have a role. But if they're seen as a support, an expert support to the primary decision maker, then they would need to decide whether a psychiatrist was needed in every case. And we know from Oregon that over the years psychiatrists were involved very frequently at the beginning of the process, and now are involved by request in around 3% of completed assisted dying cases. We don't have data on what the involvement is across all requests.
Thank you. And actually, this is convenient because my question sort of follows on from that. So, on our first day of evidence, we had Chris Whitty, the Chief Medical Officer, saying that when you're assessing capacity, the vast majority either clearly have capacity or clearly don't have capacity, and there's a small section of people there. So I was just going to ask you, Michael, would you say that a role of a GP would be to inform those, definite yeses or definite nos, and then perhaps not have the skills for the intermediate ones? I just suggesting that.
I think we could, as GPs, we can assess capacity. I think in this situation, the college's position would be that we feel the GP should not be part of the assisted dying service, that we would see a standalone service that we can signpost our patients to. Because the GP role may go on to a different route afterwards. It may be part of other things with the palliative care, looking after the families. And we think that for some GPs, yes, they may want to be involved, they may want to take that step, but we know that from our membership surveys, we have around at least 40% in the past of members who absolutely would not want to have any part in that. And so similar to other services like termination of pregnancy, we think that probably the best option would be that a GP could signpost to an information service, something like the BMA suggested the other day, that they would not have to do more than that. They would not withhold any option from the patient. We could discuss that these things exist, but we would not be doing that capacity assessment. Obviously, to give patients information about what they're going to, as you know, we would assess their capacity. Are they able to take that information in, retain it, do the right thing with it for them? And so we would be doing that level of capacity assessment, but not further on in the process where you're assessing whether a patient is able to make a decision or final decision. And I think Chris Whitty referred to the various levels of capacity as the decision gets more difficult, more complex, you're wanting a greater understanding with the patient, that they really know the implications of what's going on, and that it just isn't something we would be doing in general practice.
Daniel Francis.
Thanks, Chair. My question is for Dan Scorer. So within the Mental Capacity Act, of course, the definition of capacity would mean that many people with learning disability are presumed to have capacity. And so really it's just to understand, we've heard comments from others on the panel, whether you feel that the existing provisions within the Mental Capacity Act would cover those with learning disability, or whether you need that greater advocacy as you've discussed, or something different to the Mental Capacity Act. And also if you've got any comments about the fact that family members, lifelong carers in many cases, would have no requirement, either within the bill or of course within the Act, to be involved in the decision or to comment themselves on their family members' capacity.
So, the Mental Capacity Act starts from the principle of presuming capacity. And so the question would be whether someone in putting themselves forward for assisted dying who is terminally ill, whether doubts start to emerge about whether they actually do have the ability to make that decision, in terms of whether they can understand the information, whether they can retain it and weigh it and communicate their intentions. I think our concern in this, as I mentioned earlier, is how those discussions around assisted dying are initiated, and that for many people with a learning disability who are terminally ill, who are in an incredibly vulnerable position, doctors are very important, influential figures, and having a doctor come to you and say, what do you think about assisted dying? Is that something that you might want to consider? Could put them onto a potentially accepting or moving towards a course of action that they'd never considered before. That's why I was saying that I think having advocacy support around that discussion, and as you were saying, potentially the role of families, individuals, should be able to choose who supports them in terms of that discussions, whether it's friends or family members, whether it's an independent advocate, which I think would probably be our preference, who is specifically trained to support people with a learning disability who are considering their end-of-life options. So I think there's a lot that could be done in addition to what's in the bill already to potentially much better support people who are considering end-of-life options, and also to have other professionals who could be inputting into multidisciplinary discussions, potentially around capacity assessment.
Thanks, Chair.
Better.
Thank you, Chair. I take that on board fully, so thank you very much. That's really helpful comments. I've got a bit confused here. Let me have a look. Where am I looking? Because I was very absorbed in what you were saying. Sorry. So in terms of capacity assessment, in the feedback and the written evidence for the Royal College of Psychiatrists, it does talk in point 12 about having multiple opportunities to assess capacity, and they are in the bill, just to provide reassurance on that. So that I think there's 4 or 5 opportunities to assess capacity. My question really relates to point 15 in your written evidence around the Human Tissue Authority, because this is a model I'd looked at in terms of the decision making around coercion and capacity around people who are involved in organ donation. That's my understanding. So could you tell me a little bit about that, and whether you think there are parallels, because it's a very serious decision, so we're in that sort of territory, what that sort of looks like and what the role of psychiatrists are. And indeed, we've talked a little bit about it already, but if we were going to take this multidisciplinary approach, which I think is really powerful, what the role of psychiatrists should be, that'd be great. Thank you.
So on the role of a sort of an oversight group, one of the risks in individual practitioners doing these sorts of assessments is that they may do it once or twice in their career. What we know actually is likely to happen is that a smaller number of practitioners will likely do lots of assessments and build up individual expertise. However, it might be that a particular practitioner only does this for a patient they know or a few times. And therefore, in terms of building up the sort of expertise in terms of repetition that somebody like me might have in the mental health care of an older person, thousands of patients over a couple of decades, is that an external group that are able to understand what the standards should be, what the process should be, to be able to scrutinise things at the time, And that there are a number of bodies that do that, not just in terms of organ donation, but across lots of different services. So, you know, we have them for Liaison Psychiatry, they might have for ECT services, for example, that these are not extraordinary or unusual. But what they do is make sure that there is some consistency and reliability and that the assessments are of a standard. Because, of course, scrutinising assessments after somebody has completed the process is useful for everybody who comes afterwards. It may not ensure that the quality was there for the that individual. So that would be the rationale for that sort of approach. And forgive me, would you ask me the second part of your question again?
I think you've answered it, to be honest, but just whether there was any specific detail about the Human Tissue Authority and how that operates and what that looks like.
Yeah, so I don't have lots of individual experience with that group because I don't work within a specific service. But it's an example of a model that's in operation that, and hopefully I've described the sorts of characteristics and why they're there.
Yeah, thank you very much.
Neil Shatton-Hurst.
Thank you very much, Chair. My question is directed to Dr. Mulholland. Firstly, thank you to the Royal College of General Practitioners for their helpful written evidence. I want to pick up something within it. It's summarised at paragraph 6, but gone into slightly more detail at paragraph 7. And that's around the refusal of practitioners to engage in the assisted dying process. And I note the wording that has been used by the Royal College, which is that GPs, or in fact any other healthcare professionals for that matter, can refuse on any ground. Now that's distinct from, say, the Abortion Act, which at section 4.1 sets out that it could be on a conscientious objection. Can you explain why you've decided to take what appears on the face of it a broader expansion of that definition, and why you've chosen that particular wording?
Thank you. I think we are aware that we have a range of views in the RCGP across general practitioners. Some of them have very strong views for or against based on moral grounds, and some of those are based on religious grounds, traditional conscientious objection grounds. But others do not want to take part in assisted dying just because they don't want to. They don't feel it's part of what being a GP is. They don't feel it's part of what they trained for. In discussion with colleagues today, someone was sharing with me that for 35 years they have spent their time trying to extend the life of patients. That has been our role, and to help them towards the end of life. And it's a philosophical change if they were starting to think there's another part of this, that should the patient's life end earlier. And so there's some colleagues who may decide that for those reasons they do not want to take part in this. There will be others who very definitely do, and we have that range. So we feel that for any ground that a doctor chooses or a health professional, that they should have the right not to take part, whatever that would be, and that should be protected. They shouldn't feel the obligation to be doing something they don't feel is within their own wishes.
Naz Shah.
Thank you, Chair. My question is to Dr. Price. Dr. Price, we heard yesterday from Professor House, and we heard this morning from Professor Owen this afternoon, and they were talking very much about the issue of capacity and coercion, and they were also talking about how different people's life experiences impact their ability, impact their state of mind, etc. What I want to ask is there, Dr. Professor Owen also talked about the lack of research or evidence in that particular area that the courts are grappling with at the moment, the interfaces with issues. What I'd like to ask is there any evidence of the effect of patients' mental health when they have a diagnosis of a terminal illness or indeed a serious physical illness?
So there is a lot of research evidence about certainly around depression in people with palliative care needs and people nearing the end of life. We know that depression is common, and that across a number of studies it's at around 20%, so much more common than in the general population. We know that depression is strongly associated with a wish to hasten death, and that if depression is found and treated in that group of patients, then there will be significant change in a wish to hasten death as well. There are a number of associations other than depression with a wish to hasten death, and they include difficult symptom experience, poor functional status, so needing a lot of help with things, being socially isolated, Those are really key ones. A sense of loss of dignity, feeling a burden on others. And these things can all come together to make life feel very unbearable. And that we know that there is also an overlap between what we call a wish to hasten death, which is a response to suffering, and feeling that one is better off dead, ending their own life or harming themselves. So I was involved in a study where we asked people both the wording of a wish to hasten death and also asked them the item from the PHQ-9, which is a depression screening tool, where we asked them the suicide question. And for those who had a wish to hasten death, they were 18 times more likely to also feel suicidal, according to the psychiatric definition, than people who did not have a wish to hasten death. There is a strong association.
Thank you.
Lewis Atkinson.
Thank you. A question for Dr. Price as well, please. We heard from the Chief Medical Officer earlier in the week, who said, I quote, that he was relieved that this Act based capacity on the Mental Capacity Act, noting that it already provides for the more serious the decision, the greater the assessment of capacity, and that it is used in tens, if not hundreds of cases in the NHS every week regarding life and death cases. The example he gave was someone with refusing blood products that they would need to continue their life. So in light of that, I suppose I'm a bit confused about your evidence saying that the MCA is not suitable for life or death decisions of this type. So is it the case that you think the MCA is not fit for purpose for those current life or death decisions that are being made? Or is there something different about the life or death decisions that we've made in an assisted dying context that makes that different?
I think the assumption that the Mental Capacity Act can translate neatly into this specific decision without a really clear sense of what that would look like in clinical practice is something that needs more careful thought. So I was involved in research in this area, and one of the things that I did was to scrutinise the concept of capacity as discussed in a number of forums, for example, the Commission on Assisted Dying, in discussions in the House of Lords, and also in interviews with doctors in England and Wales and in Oregon. And what there is a broad sense of what capacity is. It can be, for some, it's a very sort of tight cognitive definition, which would mean in practice in assisted dying that most people would be found to be capacitous. Those who advocate a much broader sense of what capacity is, and these can be contained within the framework of the Mental Capacity Act, would advocate a much broader sense of what that is, thinking about values, thinking about the person's life experience, making more judgments really about that person's life in a general sense. And what I don't think we've really pinned down is what is the concept of capacity that is operating in the thoughts of this bill, and is it enough to say that we will essentially refer to the Mental Capacity Act, or do we actually need to be more specific about what is it? What is it that is capacity for this decision? And is it sufficient to say, actually, we refer out, or do we need it in the face of the bill so that anybody assessing capacity for this decision knows exactly what they should be doing, and they know exactly how they should be having that conversation? Because I think that even though you may be operating within a legal framework, that the actual conversation, the actual content will vary across practitioners. Is that good enough? Is that sufficient? Is that good enough standard? When I do a capacity assessment, I have in mind that it may be appealed against, that it may, that is somebody's right, and that should be available for scrutiny by a court. And so essentially that is the standard we're looking for. So it needs to be clear where the standard lies.
Kit Malthouse.
Thank you. I also want to just explore a little further with Dr. Price this issue of capacity, because I share the slight confusion of my colleague. Obviously, you talked about percentage who wish to hasten death, and obviously the people that we're talking about at the moment who are facing death in any event within a foreseeable period, and that death they may be contemplating one that is not pleasant. Some of the characteristics you talked about are presumably to be expected. and may not necessarily interfere with their ability to make rational decisions in what they believe is their own interest or their own best interest. So in those circumstances, I don't understand why the Mental Capacity Act wouldn't apply. I understand that you may be coming at it from a practitioner point of view, but for example, if I make a decision to decline treatment in advance of my death, to hasten my own death, I'm not sure I would necessarily see that qualitatively different from my own capacity-making point of view as me also saying, well, I know I'm going to die in 3 months' time, I'd like you to assist me to die slightly earlier, or I'm going to decline treatment and die slightly earlier. Why are the two qualitatively different from an MCA point of view? One at the moment would be dealt with through the MCA, but the second you're saying wouldn't necessarily.
Mm-hmm. So in a sense, sort of equating a refusal of treatment in capacity terms to hastening death by assisted dying. So if those two things are equated in terms of the gravity of the decision, in terms of the quality of the decision, then the Mental Capacity Act may well be sufficient. But it is there are differences. There are differences in that. There are differences in terms of what a person, what the sort of the information that the person would need, what they would need to understand, that they would need to be able to understand the impact of the what they're taking, the substance that they're taking, and what the likely positives and negatives of that are. Mm-hmm. All of those things. The informed consent process is different from a refusal of treatment. And the informed consent process feeds into the capacity assessment. And that this is an area where we need to think carefully about whether the processes of the Mental Capacity Act, as it stands, are mapped neatly enough onto that decision to make it workable.
Go to Dr. Mulholland again, just pushing a little on where you were saying the Royal College sits with members being able to say they don't want to participate in assisted dying if it came through, and some of your written evidence saying you'd like to see a separate body. Given that many GPs already are very much in the caring for their patients, will be doing often a lot of palliative care themselves, particularly for medications around, and then given that this bill is about terminally ill adults, 6 months diagnosis left to live, do you mean that all GPs would then stop at that 6 months and it would go over to an independent body? Or would you say those GPs who want to continue that care could do so, but those who didn't want to involve a potential route to assisted dying would then step out? I'd just like a little bit of clarity on that, given the person-centred care that so many GPs do so well.
I think the shape of a service isn't set out in the bill, so we would see that GPs need to have a space where they can step away from it, is the key point that we want to get across.
Yeah.
For those that want to take part, it may be they decide to do it, but would have to sit outside our core general medical services that we provide at the moment. This is an additional thing. This is something that is not part of our core job. And so we see that a separate service, which may not just be GPs in it, may be lots of different practitioners and health professionals involved, would sit better with that. So you could then assess the capacity, assess those other parts that are so important and are in the bill for the later stages. The GP may have a role, but that would be very much up to an individual GP to decide, and not to be set out that they should be taking part in that. And they then would probably be part of this additional service that we would see that others who aren't taking part could signpost to. We just want to make sure that there's that clear space.
Okay, thank you.
Kruger.
Great, thank you. Well, following straight on with that then, do you imagine it to be a NHS-funded service if it's outside core general practice? And if so, what do you think the implications might be for resourcing, assuming that it was funded out of general NHS resources? And related to that, practically to the terms of the bill, what do you think of the provision that the coordinating doctor must remain present with the person until they die, bearing in mind that might take some hours? So I'm interested in your view on the implications for resourcing the service.
Fortunately, that is not the RCGP's but I think we would be very much concerned, and in our principles we were clear that we thought there should be no reduction in core services and general practice services, nor should there be any reduction as an introduction. If this bill goes through, there shouldn't be any reduction in the funding to palliative care services that we know are often struggling as well. So this should be, therefore, had to be additionally funded. Whether it occurs in the NHS or not is not our decision again, but we would be very concerned about health inequalities creeping into any part of the health service. We're aware of the differential that occurs in lots of things, and the life expectancy, it came out in recent reports again, between different parts of the country for people that live with different levels of poverty. We would want to make sure that if this bill did come through, that again there wasn't a differential in who was able to access it. So whether that says it should be NHS or private, I'm not sure, but I think it does need to be considered as part of whatever comes out of this.
Simon Orper.
Thank you. I'd just like to go back to this depression, because I think it is common, although actually in the general population, 20% of the population is on antidepressants, on SSRIs. So, but I also more seriously wanted to say that GPs diagnose the vast majority of depressions, and I would have thought, I just wondered what Dr. Mulholland thought about whether that should be a standard part of the assessment in terms of referring people into this service before you refer them in, whether there is demonstrable depression. Because the idea that you could get a psychiatrist to see every case who wanted assisted dying, it's quite difficult to see a psychiatrist in the NHS at present. I think that would really limit the service. So I just wondered about your views.
I think we know that we see a lot of people with mood disorders of different types, of different severities, and I think many people on antidepressants with depression that we're treating carry out full functioning jobs and lives because of the treatment that they have and because their depression is not of that severity. It may be if someone had very severe depression where we were accessing our psychiatric colleagues, that would be a different decision and probably not, maybe it's not something that would happen at that point. But for most people with depression, with anxiety, with other mental health problems, they may well fit they'd have capacity because we'd presume it under the Mental Capacity Act. So I think it's not necessarily an obstruction to people being referred for anything.
Ledbetter.
Thank you, Chair. Just staying in this same sort of territory, if I can. I mean, the bill includes very clearly an opt-in model for doctors, and I took that from the BMA, who were very clear on that, and I think that is very important. My slight concern, and I'd like to expand on this a bit more if you could, is if we remove assisted dying from the holistic approach to end-of-life care and conversations that GPs have all the time, and other healthcare professions, actually, nurses, as we've heard from this week, it worries me that moves away from that holistic approach. And I think where this works well in other jurisdictions is where it is integrated. So we talk about palliative care, we talk about decision making, we talk about choices. So I'd be a bit concerned, and I'd appreciate your thoughts on that. And I think in terms of capacity, again, just reflecting on the previous session, I mean, my view in terms of psychiatric assessment is it wouldn't be necessary in every case. We've heard from 3 families this afternoon. I think we can probably all agree there was a clear wish from those individuals that this was the choice that they wanted to make. So I agree with the colleague who said there's going to be a percentage of people here, and that's why I do think referral to a psychiatrist is important in those cases. So any more thoughts on that? Dr. Mulholland would be great.
Thanks. I think as GPs, yes, holistic care is what we do, whole person care, biopsychosocial. I think we were getting the end-of-life discussion with the patient and they expressed their wish to go through a route of assisted dying, should that be legal. That might be part of a discussion we'd have with them still. I think it's the active part of the process, and the BMA referred to the word refer to a colleague for those that didn't want to do it, and we'd agree with them on that a signposting was a better process. I think we wouldn't want to be out of the patient's life, and it's very difficult to be out of that patient's life, but it may be we're not part of that particular aspect of their care. And that's the same when we refer to surgeons in hospitals. They have an episode of care elsewhere. This would be another episode that someone might be undertaking for that person, because we will still have the families that we're part of. We will still be caring for them as well. Yeah. So we don't see them leaving general practice or general practitioners, but we see that the assisted dying part of their health journey or death journey would be something that is maybe outside some people's experience, expertise, but you would need experts, people trained in it, to be doing it, and not necessarily every GP.
That's really helpful.
Dr. Price, quickly.
Thank you. To quickly add that no matter what the reason is that somebody enters this process or what the outcome is, we're very clear that anybody should be able to access really good evidence-based care, so that this should not in any way derail or deflect or make people not think about really good care, really thorough assessment, having the right professionals involved in their care, and having treatment where they need it and they would benefit from it, with all of the quality that we have, all of the guidelines that we work to, that they should still be adhered to. We should still be providing all of the other good quality care that we can, and to not bypass that, to not shortcut because they have made that decision.
Three people left that wanted to ask questions, so can I please beg for brevity? Nasha.
Thank you. My question is to yourself, Dan. Under clause 4.2 of the bill, doctors are allowed to raise the issue of assisted dying with a patient unprompted. Dr. Rachel Clark gave evidence to this committee that in some circumstances, the very act of raising assisted dying in that way will make vulnerable patients think, God, is this doctor telling me that my life is not worth living anymore? And we've heard from Dr. Jamila yesterday, who talked about the mistrust with the NHS, in particular post-COVID, where people had DNRs attached to them, people with disabled people and people of ethnic minority backgrounds in particular. Are you concerned about the potential impact of this on people with learning disabilities?
Yes. So one of the first things I said earlier was around how that initial conversation, how it's initiated, is potentially an extremely risky and dangerous moment for people with a learning disability who are terminally ill. So I think, your question is absolutely spot on from the point of view that it could be highly suggestive and push people in a course that they may not want to go down. So that's why I was suggesting that initial conversation has to be incredibly well supported and structured. So there should be, in our view, be an advocate who is supporting the person and preparing them for that discussion. In terms of the principles of the Mental Capacity Act, the person should have accessible information in advance of that discussion, so they're fully informed about all their rights in terms of treatment options at end of life. And that discussion with the clinician shouldn't be taking place until the person's been able to consider that information, have support from an advocate, so that when that conversation does happen, the person is fully informed and has had time to think about what their wishes might be. And so we reduce that risk, which is absolutely there, that people could take the initiation of that discussion as that statement you said about saying this is what you should do. And we absolutely don't want people to be in that position. We want there to be strong safeguards and support in place if this bill moves forward and becomes law.
Thank you.
Maritin.
Thank you. This is a question for Dan again. I'm really keen that we ensure that if this bill passes through Parliament, that the voices of disabled people are continually involved in understanding its impact, particularly picking up the issue that you've just raised. Earlier we heard from other people giving evidence about implementation task forces that are used in other jurisdictions. How might we, and I'm considering putting in an amendment around an advisory council, how might we ensure that the voices of people with learning disabilities can be included in such a body?
So I think there are a couple of things I'd just like to say in response. One is around clause 31, which is the guidance from chief medical officers. So immediately I would say that people with a learning disability should be involved in the development of that guidance from chief medical officers, and that guidance will be key in terms of many of the issues that we've been discussing. I think also, just in terms of clause 35, the review of the Act, I think the lived experience of people is absolutely vital to that. And our view is that I think we have, the bill says 5 years until we have that review. Our view is that's far too long, which is if there are really serious issues and discrimination taking place against people, if this becomes law, we want to know a lot earlier than 5 years, and we want action to be taken. So our suggestion would be that review should be earlier, and we would want to see strong representation from patient groups across that, and people who've been involved, family members, for example, who've been involved in the process, advocates who've been involved in the process, clinicians, to make sure that if there are serious issues being raised, they can be picked up early on and addressed.
Thank you, Chair. It's late and I'm far from the expert on Welsh devolution, but I just wanted to ask Professor Lewis, if I may, not least because we haven't come to you for a little while. I mean, while it's not my area, I absolutely note the concerns and the discussion made about the respecting the democratic will of the Senate in these matters. Are there any suggestions you would make or potential avenues to this bill that would incorporate an element of positive affirmation by the Senate or consent from them? What would you suggest we look at?
Formally, there's a need in any event for a legislative consent motion in relation to the very specific bits I mentioned earlier. I have suggested one potential avenue, which is that the Senedd and Welsh Government take on responsibility for whether and when the Act commences in Wales. Another option might be to do a thorough sort of think once, think twice, think Wales review and see to what extent this should be, other functions of the Secretary of State might be ones which would be better exercised in Wales by the Welsh ministers. That's a non-exhaustive list, but I hope it helps.
It's helpful. Thank you.
If there are no further questions, very quickly then.
Dr. Annabel, Dr. Price, you talked about depression in your evidence earlier. So, and then one of our committee members suggested 20% of people were on antidepressants, and actually the factual position is 10 to 11% of the adults in this country are on antidepressant medication. That's according to the latest statistics. I just wanted to ask, I'm wanting to make it really clear that people who are depressed, are you saying they are more likely to go down the road of assisted dying?
So the evidence that we have from research, and this is in populations with who would fulfil the criteria in terms of terminal illness, the prevalence of depression is around 20%, and that's across a number of populations. It is associated with a wish to hasten death, and that the depression might impact upon that person's decision making. So I'm not saying it absolutely would, but it might do. And it also, with treatment, might change their view. So what we do know is there's a strong association, for example, with pain and a wish to hasten death. So unresolved physical symptoms make people want to die. And when that pain is better, people no longer feel that way. And that's borne out in my clinical practice. We will get urgent referrals to see somebody who wants to die, and they're very concerned about them. And then the pain is under control. We see them that day or the next day, and they say, do you know what, the pain's better, and I don't feel like that anymore. So when we think about symptoms, we need to think carefully about what is treatable and what is remediable. And that may be psychiatric interventions, but it's often a biological, psychological and social approach.
Thank you. Can I thank the panel for their attendance and their evidence today? We're really appreciative of your attendance. Point of order, Daniel Francis.
Thank you, Chair. Yesterday we heard evidence about the impact of the bill as proposed on different groups with protected characteristics, including age, disability, race and sexual orientation. We heard from the EHRC, an arm's body of the government, that they strongly recommend a full impact assessment, human rights assessment and delegated powers memorandum to be undertaken before the committee begins its line-by-line scrutiny. We also heard from witnesses the impact the bill will have on disabled people from Disability Rights UK and others, on black and minority ethnic people from Dr Jamila Hussain, from LGBT people from Baroness Faulkner, and those from a low-income background from Sam Royce and from Mary Curie. We heard from Dr Sarah Cox and Dr Jamila Hussain that their work evidence showed that this bill has a high probability of pushing minority groups further away from seeking healthcare while inequality pre-exists. As observed through the pandemic and from available data, minority groups do not always trust that their interests will be best represented in institutions which would enable the facilitation of someone's death should this bill become law. Therefore, I believe that on the basis of their advice, so as not to inadvertently widen health inequalities for this bill, it's essential to have these health impact assessments And while I appreciate that an equality impact assessment will be produced for report stage, it will not be available for the line-by-line detailed scrutiny. And when we agreed the timetable for line-by-line scrutiny last Tuesday, we were not aware that this assessment would be produced, given it was first reported to the House during the money resolution last Wednesday. There's a risk that there is a bigger impact on people with protected characteristics, and this will not be understood fully until the government has produced the equality impact assessment. As it stands, this means we will move into line-by-line scrutiny of the bill on the 11th of February without a full understanding of how this assessment will impact on the bill. Therefore, I am minded to request a short adjournment of the committee so that, as advised, we can receive the assessments before we progress to line-by-line scrutiny. And please could you therefore advise me, Chair, how I could secure such a motion to adjourn the committee until we're in receipt of the evidence as advised by the witnesses yesterday.
Point of order, Sarah Sackman.
In light of the point of order that's been raised, I just want to clarify the government's position. As you know, government is neutral on the bill, but we are committed that after the committee has concluded its work and prior to the report stage, that the government will publish, firstly, the ECHR memorandum, a delegated powers memorandum, the economic impact assessment, which was committed to during the money resolution debate, and an assessment of the equalities impact of the bill. And in terms of the timing, and the point that was just raised there, it's necessary that the impacts that are assessed are of the bill as it is brought forward. And if that bill is liable to change with amendments that are proposed by members of this committee, it's important that we know what it is that we are assessing the impact of. And that's why the timing is being proposed to publish the impact assessment at that stage. The point is that all the members of the House, when they come to vote at third reading and prior to report stage, will have before them the impact assessment in respect of equalities and all those other aspects of the bill.
I'm going to proceed now, and I thank the member for notice of the point of order, and I'm sure the member in charge, and we know the government have heard the points that he is making. If the honourable member wishes to look at procedural options, he should consult the clerks in the Public Bill Office. That brings us to the end of today's session. The committee will next meet at 9:25 on Tuesday the 11th of February to bring line-by-line consideration of this bill. I invite Bambos Lambos to move the adjournment.
I beg to move that further consideration of this bill be now adjourned.
The question is that further consideration of the bill be now adjourned. As many of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. The ayes have it. Order.